इसमें ना देयर इज वन इशू, पिछली डेट भी देना, जो नीचे पार्टी था ना, देखो वो था डिविजनल फॉरेस्ट ऑफिसर सुकेत फॉरेस्ट डिवीजन, ही वाज द रिस्पोंडेंट, और आपने जो रिट फाइल की हुई है, द रिट हैज बीन फाइल्ड ऑन द एफिडेविट ऑफ कंजर्वेटर ऑफ फॉरेस्ट मंडी, ही इज नॉट अ पार्टी इन द पिटीशन, की है कि स्टेट ऑफ एचपी थ्रू एडिशनल चीफ सेक्रेटरी बना दो, अगर वो अलाउ भी कर देते हैं, then also how can the petition be maintained on the affidavit of someone who is not a party? डीएफओ के पे कर देते आप, डीएफओ पे क्या प्रॉब्लम थी? ठीक है जी, हैं? इसको मैं परसों रख लेता हूँ, यू हैव इंस्ट्रक्शन, इसको सिंपली डे आफ्टर टुमारो, या फिलहाल मैं नोटिस कर देता हूँ, देखी जाएगी, पर ध्यान रखना ये चीजें नोटिस कर दो, इसमें तो नहीं है ये इशू, दोनों नोटिस कर दो। 110 की एप्लीकेशन जो है ना, उसको लिखना इन द लाइट ऑफ द अवर्मेंट्स मेड इन दिस एप्लीकेशन, द सेम इज बाय एरिंग State of Himachal Pradesh through Additional Chief Secretary Forest as petitioner number 1 in the facts and circumstances of the case. Taking into consideration the fact that the आप ऐसे करो, मैं कुछ बोल नहीं रहा हूँ, बस इतना लिख रहा हूँ इसमें, ठीक है, 110 तो अलाउ कर दी, आप एक एप्लीकेशन दे देना 110 की उसकी तरफ से भी।
Lordship, this is a contempt petition in a transfer order, Lordship.
In a transfer order? Show me the order.
For case, Lordship.
Don't worry, show me the order.
Lordship, C2. Otherwise, this is complied, Lordship, by the respondent.
Complied with? So it has become infectious?
No, infectious, Lordship.
Okay, इसमें लिखना when this case was taken up for consider, इनकी notice नहीं करना, स्टेट की प्रेजेंस लगानी 1 से 3 के लिए। When this case was taken up for consideration to relevant counsel for the petitioner. अजय धीमान का केस है ये? अजय आपका केस है ये? आप कौन से केस में रिक्वेस्ट बोल रहे हैं?
S3 सर।
कौन सा लिया हमने? डोला राम एंड अदर्स।
ये तो हमारे
रिट है
ये हमारे।
हाँ, जस्ट आपका कौन सा दोस्त?
मेरा S3
नहीं, S4 आपका S4 आपका नहीं हुआ है, किसी और कोर्ट में तो नहीं है? देखो डोला राम, यस
please, in this case, sir, the order, the demarcation application was filed, Lordship, and the demarcation application was dismissed in default, Lordship. Thereafter, the order was reviewed by the Assistant Collector, Grade 1, Lordship, and the Assistant Collector, Grade 1, Lordship. Thereafter, the application for restoration was filed, Lordship, before the learned Assistant Collector, Grade 1, Lordship. The application was time barred, Lordship, and there is a period of 30 days for filing the application, Lordship, and there is a provision of appeal against the order passed by the.
Show me the order passed by the Divisional Commissioner.
Yes, Lordship. Lordship, page 81, Lordship.
Page
81, Lordship. 80 and 81, Lordship. Lordship, last lines, Lordship. The perusal of order dated.
Show me the complete order.
Please, Lordship. It is at page number 78. 78 to 81, Lordship.
Let us read.
Please, Lordship. Brief facts of the case are that the President has filed an application for demarcation and issuance of the spot mat in respect of the comprise in Khasra number so and so, the Tahsil Karsok District Mandi, before the Assistant Collector First Grade Karsok, which application was dismissed in default by the Assistant Collector First Grade Karsok on 17/7/2017. The present respondent filed an application dated 23/9/2017 before the learned Assistant Collector First Grade Karsok, hereinafter referred to as the AC First Grade, for setting aside the dismissal order dated 17/7/2017. The grade allowed this application as per the order dated 6/12/2018. Feeling aggrieved and dissatisfied with the same, the present petitioner filed appeal before the learned before the Collector Subdivision, Joginder Nagar, so it is Karsok, Lordship, and who dismissed the same as per order dated 7/2/2019, feeling aggrieved and dissatisfied with the same, the petitioner have now filed the revision petition before this court. The main grounds taken in this revision petition are that the delay cannot be condoned without an application for condonation of delay under Section 5 of Limitation Act. There is specific period of limitation, and as such, the order passed against the petitioner and in favor of the respondent is void ab initio. That the trial court has no jurisdiction to set aside the ex parte order dated.
To page 86.
Please, Lordship. 86, Lordship. From perusal of the aforesaid recommendation, Lordship, it is clear that the learned commissioner has referred the case mainly on the ground that the application under Order 9, Rule 13, read with Section 151 of CPC was preferred after lapse of period of limitation, but the same has been allowed by the AC first grade on 6/12/2018 without assigning any reason whatsoever, that too without any explanation for condonation of delay. That further, the collector has rightly arrived at the conclusion that the application for restoration.
What is wrong in the order? It is
Lordship.
The order passed by the authority is an equitable order.
Yes, Lord.
It is an equitable order.
Yes, Lord.
No prejudice is going to be caused to you. There were proceedings pending.
Yes, Lord.
Proceedings were dismissed in default.
Yes, Lord.
ठीक है ना?
Yes, Lord.
उसकी restoration की application आई है.
उसकी restoration की application.
वो time bar थी.
Which is time bar.
जो मर्जी था. It is just a procedural issue which has been set at rest by the authorities.
Yes, Lord.
It is to contest whatever is the issue on merit.
On merit.
So फिर आपका why are you shirking?
I am, Lordship, on the ground that Lordship may kindly have that the dismiss in default, last line, Lordship. Further, it is settled principle of law that the period of limitation starts from the date of knowledge, Lord. But it is not from the date of knowledge, Lordship, where the period is specifically mentioned, Lordship, as per.
How much delay?
67 days delay, Lordship.
7 days delay.
Otherwise, there is.
Are we joking?
No, Lordship.
67 days delay in
delay,
the
Lord.
court.
How
much time is taken by the honorable brothers and sisters of mine in condoning 67 days delay? Application filed under Section 5
by
Mr. Ajay Dhiman.
Please, Lordship.
How much time is taken by the High Court? Not even 6 seconds.
No, Lordship, it is not the case. Lordship, here is the case that without an application, Lordship.
There is no question of application. Or कर भी दिया है, what prejudice is caused to you?
On the ground that the order is appealable, Lordship.
What prejudice?
He cannot review his own order, Lordship.
To you. What prejudice?
Lordship, earlier twice, Lordship, he has taken the demarcation, Lordship. I have annexed the document.
Go and contest it on merit. Go and contest.
Well, Lordship, I have already the demarcation has been.
Please go and argue the case before the authority. Financial.
Otherwise, Lordship, there is a period of limitation, Lordship, has been prescribed, Lordship. And in the act, Lordship.
एक चीज का देखना, कल से आप आओगे ना सेक्शन 5, तो फिर सुप्रीम कोर्ट की वो जजमेंटें लगेगी that each minute, each hour has to be explained. According to me, it is a very reasonable order that has been passed by the learned financial commissioner. Financial commissioner simply says, please read. He says that otherwise also. Please read page 86.
Yes, sir.
The collector has rightly arrived at the conclusion that the application for restoration was time barred, but he has justified the action of the trial court for restoring the demarcation application on the ground that order dated 17/17, whereby the application was dismissed in default, itself suffered from procedural lapses as no summons were issued to the present respondent to be present on that date.
But, Lordship,
they demonstrate that the findings that have been so returned are perverse. Demonstrate.
Lordship.
So here is a case.
Yes, sir.
Where a matter is listed on a particular date.
Yes, Lordship.
Without informing the party that the matter is being listed today.
No, Lordship.
सुनो मेरी बात. तभी मैंने बोला ना sir, demonstrate that the findings are perverse.
Yes, Lordship.
What the authority says is this.
Yes.
Case is listed on 17/7.
Yes, Lordship.
On that day, it is dismissed in default.
Yes, Lord.
As per the record, no summons was issued to the party, informing the party that the case will be taken up on Stara South.
Yes, sir.
If this is a fact, then you expect that a party जिसको यही कि एक पर्टिकुलर डे पे मेरा केस लग के वो डिस्मिस इन डिफॉल्ट हो गया, आप उससे उम्मीद कर रहे हो कि वो कोर्ट भी आए, दफा 5 भी लगाए, ये भी करे, वो भी करे.
Otherwise, Lordship may kindly have the page 56, Lordship. In that case, Lordship, the earlier the summons were.
I am not interested. This is a case of judicial review. I am exercising my power of judicial review. I am not sitting here as an appellate court. Demonstrate that the reasoning assigned by the authorities are perverse. I'll interfere.
Because, Lordship, he has on reviewing his own orders, Lordship may kindly have the order on review, Lordship, it is page 65, Lordship.
That is not under challenge.
That is under
That is not under challenge.
because, Lordship, the procedure
Under challenge is the order passed by the
learned commissioner, Lordship.
commissioner.
Financial commissioner, Lordship. Lordship, may kindly have the order dated 6/12/2028, Lordship. The application dated 23/9/2000 under section 9 was taken along with the
कोई illegality नहीं है.
The argument-
Why are you? Why are
otherwise, Lordship, the earlier Lordship, he was attending the court, Lordship, on the in the same court.
सिर्फ एक चीज का जवाब.
Yes, Lord.
That is not the issue.
Yes.
So people are attending this high court for how many years now?
That is the law.
कितनी प्रैक्टिस होगी आपकी? तो अगर कोई आपका केस डिसमिस इन डिफॉल्ट हो जाता है इन सर्कमस्टांसेस कि अजय धीमान को पता
नहीं जी, उसको तो पता था ना।
नहीं पता था सर?
नहीं पता था जी उसको।
प्लीज, मैंने आपको 3 बार बोला है अंग्रेजी में, डेमोन्स्ट्रेट दैट द फाइंडिंग्स आर परवर्स। शो कि जो अथॉरिटीज कह रही है कि 17/7 को उसको समन ही नहीं दिया हुआ था, उसको समन था, डेमोन्स्ट्रेट क्यों था? मैं भी सेटिस्फाइड कर देता हूँ।
केस 7/7/2017 Lordship, page 56 Lordship.
17/7/2000
Counsel of the applicant Shri K.L. Mahindru is present. The presiding officer is on tour. As such, hearing of the missile are fixed for the 7/2017. 2017 को case called. None is present. The concerned party are not appear.
This order is bad in law for the simple reason that recently I have also given a judgment 10 days back that जो ये क्लर्क वगैरह हैं इनको कोई इख्तियार नहीं है in the absence of the presiding judge to give any dates in the matter.
And Lordship, on the same day, Lordship, he has given statement in the same court, Lordship.
कोई नहीं है.
Otherwise, Lordship,
sitting right here, मैं आपको बताऊं, let us assume the private respondent or the private party in the court.
Yes,
और मेरे को पता नहीं है, आपको भी नहीं पता कौन है और मैं नोटिस इशू कर देता हूँ. कल को कोई बोले कि सीसीटीवी में देखो तो वहां थे, कैन दी कोर्ट टेक कॉग्निजेंस? किनको पता है? नो, दिस इज नॉट हाउ द लॉ वर्क्स. तो इसको उड़ा रहा हूं मैं.
otherwise, Lordship, the findings also which he has signed.
फाइंडिंग्स बताओ, परवर्स है तो आई विल इंटरफेयर.
Otherwise, Lordship,
there is one
limitation period की.
there is one है ना लिमिटेशन. अगर दफा 5 की
नहीं, मैं कहता हूँ दफा 5 की एप्लीकेशन भी नहीं लगाई हुई है जी.
जरूरत बट नहीं लगाई तो क्या हो गया?
नहीं जी, पर इसमें जो यहाँ पे इन्होंने फाइंडिंग दी ना कि फ्रॉम द डेट ऑफ नॉलेज, Lordship. It is not from the date of knowledge.
You have to give Mr. Ajay, please, outside judicial authority. They are not judicial authorities.
Yes.
They are not trained judicial minds. They are not trained judicial minds.
Yes, Lordship.
We are trained judicial minds. At the end of the day, issue is not how the order has been passed. Issue is what is the order passed.
Yes, Lordship.
Order is good. The order is equitable.
Yes, Lordship.
तो इसमें कुछ नहीं है.
Okay, Lordship.
होगा क्या अगर मैं आपकी बात मानता हूं? आई विल सेट असाइड द ऑर्डर, रिमांड द मैटर बैक टू द अथॉरिटी.
Yes.
फिर दफा खास देगा, फिर वहां से इशू शुरू हो जाएगा.
उसके बाद अगर उसने अपना ऑर्डर रिव्यू भी करना था ना जी, तो रिव्यू में जो सेक्शन 16 है जी एचपी लैंड रेवेन्यू एक्ट का, रिव्यू कैसे करना था उसने?
तो चैलेंज किया रिव्यू का ऑर्डर आपने? हैव यू चैलेंज द ऑर्डर ऑफ रिव्यू?
इट इज द कंटिन्यू प्रोसेस, Lordship.
कैसे?
The order was.
When was the order of review passed?
Order of review was passed, Lordship, on 6/12/2000.
Process. You are wrong.
6/12, Lordship.
Come to page 70 paper book. This is the order of review. When is it passed?
No, Lordship. The order passed by the learned assistant collector, grade 1, Lordship. It is the order, Lordship, 6/12/2028, Lordship.
Page P7. ये क्या है?
Yes, Lordship.
What is this?
It is the review
By whom?
filed by us, Lordship.
Review filed by you. Don't
Yes, Lordship.
ठीक है ना?
Otherwise, Lordship, the earlier order, Lordship, 6/12/2018, Lordship.
6/12.
6/12/2018, the collector, first grade, Lordship.
Which page?
Assistant collector, it is 65, Lordship. 65. इसमें रिव्यू है जी, रिव्यू बाय द रेवेन्यू ऑफिसर. A revenue officer may either of his own motion or on the application of any party interested review and also reviewing, modify, reverse or confirm any order passed by himself.
Where is the order of review?
It is at page number 65, Lordship. 64 is the 63, 62 and 63 is the order, and the typed copy is 65. The application dated 23/9/2017 under order 9 was taken up along with reply dated 20-10-2018. The argument put forth before this court mainly issue of the jurisdiction, delay in filing the application were considered. Orders of this court dated 10-7-2017 followed by the order dated 17-7-2017 were passed. After considering all facts, I am of the firm opinion to allow the application dated 23-9-2017, the case to resume from the proceedings of 10-7-2017. Since one party, that is R number 1, is not present, the summons be issued. Rest of the parties are served. Notice be present on 5-1-2019, announced Lordship. Then Lordship, in case he wanted to review his own order, he can review, but Lordship provided is their Lordship.
No stricto sensu review.
No, Lordship.
It is order 9 rule 7.
9 rule 7, Lordship.
Yes,
but in case he wanted to,
Mr. Dhiman, what purpose will be solved by these arguments? At the end of the day, in the peculiar facts of this case, even if the matter is remanded back to that particular person,
yes, sir.
और आप उसको बोलो कि दफा 5 की दरखास्त है वो allow, so you want to drag the clock again back by 2 years. Can the High Court set aside the order passed by the Financial Commissioner without remanding the matter back? Ultimately, what judgment will be passed by the court if you succeed? The matter will be remanded back to Assistant Collector with the direction कि इस order को मैं set aside करता हूँ और उसको फिर से decide करो 9/7 को along with an application under Section 5. तो 5 साल और पीछे धकेलना है अपने पार्टियों को. तभी मैंने पहले बोला it is an equitable order. I am not saying कि merit पे बड़ा वो है. Equitable order. It is just giving an opportunity to proceed from where they were. कुछ नहीं है इसमें.
मेरी एक बात सुनिए. इसमें जो प्रोवाइडेड है ना, जो विदाउट द ज्यूरिसडिक्शन व्हिच वी आर सेलिंग लॉर्डशिप, अजय प्लीज लॉर्डशिप, ऐसा ना दे लॉर्डशिप, ठीक, दे आर नॉट ट्रेन्ड माइंड्स. आप एक को देख रहे कि, और ये नहीं कि हमने तो उनको बताया था ना जी वहां पे कि रिव्यू में जो है कि अगर अपना ऑर्डर करना है तो आफ्टर गेटिंग द सैंक्शन फ्रॉम द अपीलेट अथॉरिटी 10,000 रुपए जमा करा दो लिटिगेशन एक्सपेंस में. जगत को राम को बुला लेता हूँ, अदरवाइज फ्रिवलेस पिटीशंस नहीं एंटरटेन करूंगा. It is an equitable order passed by the authority concerned. No prejudice has been caused. I agree with the opinion, Lordship. But Lordship, as per the review, Lordship, which he has taken his own order. There is no review. This is not review. He has recalled the order, Lordship. But even in case of his recalling the order, Lordship, he has to get the sanction from the higher authority, Lordship, which he has not taken, Lordship. और साथ की उसमें थोड़े रिव्यू हायर अथॉरिटी जी रिकॉल करना हो ना जी. इसमें सैंक्शन का लिखा हुआ है कि व्हेन द कमिश्नर और कलेक्टर थिंक्स इट नेसेसरी. क्वेश्चन व्हाई शुड समवन प्लीज रीड द जनरल क्लॉजेस एक्ट. अथॉरिटी whichever authority has got the power to do an act, it automatically has the power to undo that particular act. This is the provision of general clauses act. But Lordship, as per the HP Land Revenue Act, Lordship, दिखाओ जरा HP Land Revenue Act. The order is appealable, Lordship. There is no question of appeal. No, Lordship. The question is very simple. Yes, Lordship. If let us assume this matter is dismissed in default. Yes. Lord. What remedy is before you? We have to file the application for recalling. Or recalling. So it is not review. Yes, Lordship. There is a subtle difference. But Lordship, review is of an error apparent. Yes. So error apparent के लिए नहीं क्या कोर्ट में? No, Lordship. Because court was not wrong. जब आदमी आया ही नहीं, उन्होंने जब उसने reasons explain किए, तो कोर्ट ने बोला ओके आई एम रिकॉलिंग द ऑर्डर. और जो पोजीशन थी जब मैंने किया था उससे पहले चल पड़ते. इनफ हो गया. Because by way of this petition, the petitioner has stayed for the following. The petitioner is aggrieved by the Annexure P9. Don't worry, I'll find it. By the order passed by Learned Financial Commissioner Appeal in revision petition number 18 of 2020 titled Dola Ram and others versus Jagat Ram, dated 3rd of August 2024, in terms whereof the recommendation made by the learned Divisional Commissioner Mandi in case number 104 of 2019 titled Dola Ram and others versus Jagat Ram, dated 8/2020,
to the Learned Financial Commissioner Appeal, Himachal Pradesh under Section 17 within bracket 3 of the HV Land Revenue Act for passing an appropriate order on the strength of the order passed by the Learned Divisional Commissioner has been declined by the Learned Financial Commissioner, and the brief facts necessary for the adjudication of this petition are that an application for demarcation and issuance of spot map was preferred by the आपने फाइल की थी
जी जी रेस्पोंडेंट
कहाँ पे है वो
जगत राम लॉर्डशिप इट इज एट पेज नंबर 46 लॉर्डशिप annexure P2 लॉर्डशिप
मैं वही लिखा रहा था जगत राम कौन है अच्छा सॉरी
जगत राम रिस्पोंडेंट हम तो
बस क्या लिखा मुझे that an application of demarcation and issuance of spot map was filed by respondent Jagat Ram, private respondent Jagat Ram, in the court of learned assistant collector first grade Karsok, in which the present petitioners were impleaded as the party respondents. A response to the said application was filed by the present petitioner. It appears that the application by Jagat Ram was dismissed in default on, as per the record, it appears, as per the record, the application filed by Jagat Ram for demarcation was dismissed in default on 17/7/2017.
Yes, Lord.
An application under Order 9, Rule 13, read with Section 151 of the Civil Procedure Code.
It is at page number 57 and 58.
मेरे पास है वो. अब आप कह रहे हो ना हमने अब now just see कि dismiss in default की restoration के लिए application जो फाइल हो रही है वो 9/13 में and for setting aside ex parte order.
हाँ जी.
तो ये तो लियाकत है हमारी बात की. ऐसे लिखना आपने क्या लिखा an application for recalling the said order in terms of annexure P with the petition was filed by Jagat Ram, in which it was averred that the applicant was not aware of the matter being listed on 17/7/2017 for the reason that on the last date preceding 17/7/2017, i.e. 7/7/2017, the presiding officer was on tour and the case was fixed 10/7/2017 with the remarks to recall the parties. It was further averred in the application that thereafter no summons were received by him for his presence for 17/7/2017. This application was allowed by the authority on 6/2018. In the following terms, यार ये ना इसकी ट्रांसलेशन तो है दी 65
ट्रांसलेशन
कंपेयर कर लेना 62 63 और 65 है ना पढ़ लें फुल स्टॉप. Feeling aggrieved, the petitioners herein preferred an appeal under section 14 of the HV Land Revenue Act against the order passed by the authority dated 6th of December 2018 inter alia on the ground that आपकी ग्राउंड ऑफ अपील कहाँ है? नहीं लगाए हैं? नहीं लगाए हैं?
नहीं लगाया.
क्या है रीजन क्या था?
Otherwise, the grounds are there that the jurisdiction on the ground of jurisdiction lordship, and without the application lordship, because he cannot recall his own orders lordship.
क्या लिखा आपने? हाँ, preferred an appeal again. हाँ, dated so. In terms of annexure P6 dated 7th of February 2019, the appeal was dismissed by Sub-Divisional Collector Karsog. Don't worry, मैं ये पेज 70 से लिखना आपने है, पैरा 5 से आगे करना है 71. Thereafter, a review petition was filed by the petitioners against order dated 7th of February 2019, and the same was allowed by Sub-Divisional Collector Karsog on 4/2019 video annexure P7. This was followed by order dated 8th of January 2020 passed by Divisional Commissioner Mandi in case number 104 of 2019. नहीं मैं क्या लिखा, सॉरी क्या लिखा रिव्यू में, क्या लिखा आपने? उससे पहले हाँ, by the petitioners. हाँ नहीं, and the same but the same was dismissed by the Sub-Divisional Collector Karsog video annexure P7 dated 23/4/2019. सर अब आप मेरे को ये बताओ, आपकी रिवीजन पिटीशन कैसे मेंटेनेबल थी बिफोर द डिविजनल कमिश्नर?
As per section.
बताओ. What the petitioners did was this: despite the fact that there were 2 orders passed by the sub-divisional collector, one in the appeal,
yes,
and other in the review.
In the review.
आपने रिव्यू का डिसीजन चैलेंज कर दिया, मेन अपील का डिसीजन चैलेंज ही नहीं किया, तो रिवीजन कैसे मेंटेनेबल थी?
Otherwise lordship.
अदरवाइज नहीं.
Lordship में कैंडी lordship.
पढ़ो आप प्लीज काइंडली. डिविजनल कमिश्नर के पास आपने चैलेंज किया डिवीजन पिटीशन अंडर सेक्शन 17 अगेंस्ट ऑर्डर डेटेड 23/4/2019. दिस वाज द रिव्यू ऑर्डर. रिव्यू ऑर्डर थोड़े चैलेंज होना था, मेन ऑर्डर चैलेंज होना था. तो आपने
it is a part of that.
Don't teach us law now.
Yes sir.
पंडित जी बैठे पीछे बीपी शर्मा जी, उनसे पूछ लो. It is settled law. Review does not condone the delay for assailing the main order. और अगर वो हो जाता, you could have challenged both the orders, but in the absence of there being a challenge to the main order, ये तो था ही नहीं मेंटेनेबल. ये तो और आसान हो गया. हाँ जी, क्या लिखा आपने? वो डिसमिस हो गई, ठीक है ना? This full stop. Feeling aggrieved The petitioners preferred a revision petition under Section 17 of the HP Land Revenue Act 1954 against order dated 23/2019 passed by the collector subdivision Karsog, i.e. the order passed by the collector in the review petition. However, no revision was preferred against the order passed by collector subdivision Karsog dated 7th of February 2019 in the appeal that was preferred by the present petitioners, meaning thereby that there was no challenge to the main order passed in the appeal by collector subdivision Karsog. The revision petition was allowed by Divisional Commissioner Mandi with the order dated 8/1/2020 by assigning the following reasons. Page 87, 80, 81, X2X. This order has been, the recommendation made by the Divisional Commissioner Mandi has been declined by the Learned Financial Commissioner Appeal in terms of the impugned order. Annexure P9 dated 3/8/2024. Syed Himan, Learned Counsel appearing for the petitioners, has strenuously argued that the order passed by the Divisional Commissioner Mandi was a reasoned order and there was no occasion for the Learned Financial Commissioner Appeal to decline the recommendation and dismiss the revision petition. Learned Counsel submitted that as the application filed for restoration, that as the application filed for the review of the order, in terms whereof the application filed for demarcation was dismissed, and secondly, as there was no application filed for condonation of delay in moving the application, the order of review passed by the first authority was per se bad, as was also correctly held by the Learned Divisional Commissioner, and this extremely important aspect of the matter has been ignored by the Learned Financial Commissioner. Having heard Learned Counsel for the petitioner and having carefully gone through the orders appended with the petition, including the impugned order, this court is of the considered view that there is no infirmity in that has been passed by the Learned Financial Commissioner appeal. As is evident from the facts that have been narrated by me herein above, the application which was preferred by the private respondent herein, with annexure P4, though is ill-worded, but the same was simply for recalling the order that was passed by the authority dated 17/7/2000, in terms whereof an application filed by Jagatram for demarcation of the land was dismissed. The authority recalled the order by assigning the reason that there was indeed no summon issued to the said applicant for his appearance on 17/7/2017. This court called upon Learned Counsel for the petitioner to demonstrate that the findings so returned by the assistant collector, as were also upheld by the Learned Financial Commissioner, were perverse findings, but he could not demonstrate the same. On the contrary, the Jimny orders appended with the petition as annexure P3 demonstrate that when the case was listed, on 30/5/2017, the case was ordered to be on 16th of July 2017. However, on 16/6/2017, the case was ordered to be the case was listed on 7/7/2017, probably by the court officer as the presiding officer was not available. Thereafter, on 7/7/2017, again the presiding officer was not available, and the कौन होता है कोर्ट ऑफिसर क्या बोलते हैं इनको जिनके हाँ रीडर लिखना and the reader ordered the case to be listed on 10/7/2017. First of all, this court would like to make an observation that when the presiding officer was not available, the reader of the court had no business to give any dates as has been given in the dates as were given as summons were required to be issued to the parties for their presence. This stands so declared by this court in मेरी judgment देना मैं उसको यहाँ पे कोट कर दूंगा अभी दिया मैंने 10 दिन पहले है ना हम अभी दिया वो हफ्ते भर पहले की जजमेंट उसको निकाल दूंगा. Be that as it may, Jimny orders further demonstrate that on 10/7/2017, when the case was taken up, neither of the parties were present, and thereafter and it was ordered that the parties inverted comma karna summoned for 17/7/2017 inverted comma close. However, no summons were issued to the parties for their presence on 17/7/2017, and as the applicant was not before the learned presiding officer on 17/7/2017, the application was dismissed in default. It is this order which was recalled by the authority Bide Annexure P5, primarily by recalled by the authority Bide Annexure P5. This court would like to make an observation that though order dated 6th of December 2018 passed by the authority is also not very happily worded. One can figure out that it was after the perusal of the previous orders passed in the matter that the presiding officer decided to recall the order. At this stage, this court would like to emphasize that this order of recall cannot be construed to be an order of review, as was argued and stressed by the learned counsel for the petitioner. Besides this, his contention that the authority was having no jurisdiction to decide the application, is liable to be because the order to recall an order passed dismissing an application because the power to recall an order passed dismissing an application would obviously lie with the authority which has passed such like order. Other contention of the learned counsel that the application filed for recalling the order was not accompanied by any application for condonation of delay also stands any merit for the reason that in the peculiar facts when the petition was when the application was erroneously dismissed by the court, fault, even if the order was recalled without there being any formal application praying for condonation of delay, but after hearing the parties, such procedural issues cannot render the order to be bad in law. Now, in this backdrop, when one peruses the subsequent developments, one finds that against the order of recall passed by the authority, the petitioner preferred the petition appeal. This appeal was dismissed on 7th of February 2019. No revision was filed against this order dated 7th of February 2019 within limitation or otherwise by the petitioners. They preferred a review petition, which was dismissed by the which was again dismissed by the authority on 23/4/2019. Thereafter, rather than challenging the order that was passed in appeal, the petitioners only challenged the order that was passed by the authority in the review petition, meaning thereby that as far as the main order passed by the authority dismissing the same attained finality. In this backdrop, this court is of the considered view that the revision petition preferred by the petitioners before the learned divisional commissioner was not maintainable. However, Divisional Commissioner Mandi failed to appreciate this extremely important aspect of the matter and allowed the revision petition by setting aside the order passed by the assistant collector for recall of default without appreciating that in the absence of there being any challenge to the main order passed in appeal by way of revision, no authority was vested with the divisional commissioner to have had set aside the said order. In this backdrop, when one peruses the order passed by the learned financial commissioner of appeals, one finds that the reasoning assigned by the learned financial commissioner appeal in not accepting the recommendation of the divisional commissioner is equitable reasoning, which calls for no interference. In fact, as I have already observed herein above, that in the light of the fact that the revision petition which was preferred before the divisional commissioner was not maintainable, the order passed thereupon by the divisional commissioner was also having no consequence, and same can also be said of the order passed by the learned financial commissioner for the reason that at the cost of repetition, when the main order passed in appeal attained finality, other things became odious. Learned financial commissioner has only now relegated the parties back to the situation, back to the position where they were before 17/7/2017, meaning thereby that no prejudice has been caused to the present petitioners because no findings on merit in the issue have come in favor of the present petitioners, which findings have been either reversed or recalled or set at naught by the learned financial commissioner in terms of the impugned order. All that the authority has said is that the order in terms whereof the order of dismissal in default has been recalled is a justifiable order, and the parties stand relegated to the authority to agitate the issue of application or demarcation on merit. As this court finds the said order to be just and equitable, causing no prejudice to the present petitioners, and further, as this court does not find any merit in the present petition, because hypothetically, even if the present writ petition is to be allowed, then all this court can order is that the matter is to be relegated back again to Assistant Collector, Grade 1, asking him to consider an application under Section 5 of the Limitation Act that this court, finding no merit in the present petition. This is in the प्यार चंद
My lord.
8 साल से आप लोग इसी चक्कर में फंसे हुए हैं. 8
बिल्कुल जी बिल्कुल. And kindly see P2.
Yes, sir.
Deputy Commissioner Bilaspur has held that they are encroacher.
What is the matter, sir?
And Gram Panchayat President and Vice President.
Just give me 1 minute, sir.
He has held election petition is the remedy. My client filed election petition in the court of SDM Gumarmi, and limitation was condoned. The appeal was filed to the deputy commissioner. At this stage, the client came to me. In fact, no election petition is maintainable because it is a special law, and limitation cannot be. It is only the deputy commissioner's order which can be challenged by this in this honorable court. That is my crux of the point.
No, but kindly see the relief prayed for, sir. आप कह रहे हैं respondent number 2 में भी directed to decide the matter. What is the matter pending before the respondent number 2, sir? R2 के पास matter क्या है?
उसके पास मैटर यही है कि 122 पंचायती राज एक्ट के नीचे he should take action. My representation was that they are encroacher and they should be action should be taken against them.
Just 1 minute.
And he did not decide that. He decided that they may be evicted, they may be done such and such. That is the.
No, but where is your representation, sir?
My representation is not on record, my lord.
वो चाहिए उसके बिना.
Because my lord, at this stage, my prayer is only that election to the office of president and vice president is illegal because they are encroacher.
That is
And it has been finality has been attached.
Mr. Sharma, please see the prayers. आपने बोला ना, the respondent number 2 may be directed to decide the matter. I am requesting you कि कौन सा के पास pending है, I'll direct him. But what is the matter pending before the authorities?
That representation.
कहाँ पे है वो? तो आपका कॉपी है? मैं इसको 2-4 दिन बाद रख दूं, आपको रिप्रेजेंटेशन रिकॉर्ड पे ले आओ सर.
My lord, may issue notice.
नहीं, I'll decide it.
My lord.
आप उसको represent. Today is Monday. I'll order it to be listed on Thursday, sir. You place the representation on record. I'll direct the authority.
My lord, I think it was filed with the earlier petition, and this copy is not available.
Page 14.
Yes, sir.
My lord, representation for order pass हुआ है ना जी? Annexer
The filing of the instant
P1.
petition has already provided representation.
हाँ,
That's one. So it is-
वो तो decide भी होगी हुई है. That has been decided by him.
My lord,
P2.
Yes, sir.
If the petitioner is agreed by P2, he should have challenged it. वो किया नहीं हुआ है.
my lord, this.
See what has happened is. Just 1 minute, Mr. Sharma.
My lord,
Mr. Pyar Chand comes to the High Court. High Court directs the Deputy Commissioner to decide his representation.
representation, correct.
Deputy Commissioner decides the representation and says that action be taken against them for their ejectment.
After due notice and
That you are not taking the order to its logical conclusion. यही है ना जी?
that is.
Encroachers जो है वो अभी भी बैठे हुए हैं. Notice.
And they are,
Notice, sir.
my lord, 2 weeks is sufficient, my lord.
दस्ती कराना पड़ेगा प्राइवेट पार्टी.
दस्ती करवा देते
प्राइवेट पार्टी दस्ती.
दस्ती करवा देते
नोटिस 1 से 3 के लिए पुष्पिंदर, 4 और 5 को रिटर्नेबल फॉर डैश. Steps by tomorrow, dusty notices be handed over to the learned instructing council by Wednesday, sir.
my lord.
हफ्ते के बाद.
Speak.
On the next date of hearing, learned Additional Advocate General to inform the court as to what steps stand taken by the authorities in pursuance to the order passed by Deputy Commissioner concerned, i.e. Annexure P2. Sir.
My lords, my payment has been made. I will withdraw this petition, my lords.
Learned counsel for the petition.
Dispute has been resolved by my lords.
On account of subsequent developments, the petition has lost its efficacy and the prays for permission to withdraw this.
Please grateful.
Disposed of as withdrawn. Yes, Mr. Webb of Tandar.
Lordship, in this judgment dated 4/4/2025, next year C1 has not been complied with, my lord. 4 weeks time was granted to the respondents to.
आप किस देश में रहते हैं? Where do you live?
In India.
इंडिया। आप अप्रैल का ऑर्डर और आप अभी कंटेम्प्ट फाइल करें तो थोड़ा सा टाइम दो। हिंदुस्तानी सरकारें महीने में हिल जाती हैं। जल्दी नहीं हो गया कुछ? I was just joking.
Is that
What is the direction passed by the court?
Lordship, the direction.
Stage.
Please.
They have passed an order now. पढ़ो इसको last पैरा पढ़ो. And whereas the petitioner, so I'll give them time-bound directions to do the needful. इसमें लिखना आपने by way of this notice कर देना AG साहब accept notice. By way of this contempt petition, the petitioner the disobedience of the order passed of the judgment of this court dated 4/4/2025 passed in CWP number so and so titled so and so, which writ petition was disposed of court in the following terms. Para 4. The learned Additional Advocate General has handed over a copy of office order dated 13th of June 2025, passed by Director School Education. अब आपके ये हायर और एलिमेंट्री खत्म हो गया हुआ है. There is only one Director School Education. Relevant portion whereof reads as under. ये the office order is also ordered to be taken on record. In the light of the contents of this office order, the by discharging the notice, but with the observation that let the actual monetary benefits be released to the petitioner judiciously and not later than 4 weeks from today. 4 weeks का टाइम कोर्ट ने दिया था, 4 weeks में फिर से दे रहा हूँ. Yes, please.
Contempt action will not be the direction that we will decide in 10 days.
Just 1 minute. Direction क्या थी sir?
11 of the contempt order, my lord. The petition is directed to file the representation within a week.
दे दी थी.
Please, my lord.
है क्या ट्रांसफर कैसे?
Transfer matter.
वो कर देना. Appropriate order within 10 days. Undertakes the
Obliged.
वो दे देना liberty.
Please.
Yes.
It is now in practice, Lordship.
So लिख देना when the case was taken of consideration, learned counsel for the petitioner submits that the order in issue now stands complied with.
Grateful.
Proceedings closed. Notice नहीं करना इसमें. Petition is disposed of.
This is also similar case, Lordship.
ये वाला
ये भी हाँ जी.
सर वही ऑर्डर जो पहले किया था ना वेबर के केस में, सेम ऑर्डर. इसमें है इंस्ट्रक्शन
ऑर्डर तो है नहीं.
इसमें नहीं है. इसमें नोटिस करना. नोटिस हफ्ते के बाद. Instructions in the meanwhile. Next witness. Yes, please. Yes, Haminder.
My lord, I came to the honorable court, my lordship. Kindly see page annexure P1, my lord. Lordship judgment, my lord. Lordship directed that without acquisition, my land was taken away, my lord. Thereafter, my lord, LPA, my lord, the judgment is affirmed, my lord. Annexure P2. The state goes into appeal, my lord. Lordships direct that acquire it in accordance with law. State, my lord, goes in appeal. P2 is the, my lord, the judgment passed in appeal. The appeal is dismissed. Thereafter, the state goes.
आपका केस क्या है? What is the case of?
मेरा केस ये है जी, P3 में the judgments passed by this honorable court were modified only to the extent that there was a delay in approaching the writ.
Who are you?
But इनमें जो ओरिजिनल रेट पिटिशंस में आई वाज द पिटिशनर्स, और सुप्रीम कोर्ट से मॉडिफिकेशन हुई है जी, उसमें स्लाइट मॉडिफिकेशन टू द एक्सटेंट दैट आई केम टू द ऑनरेबल रेट कोर्ट आफ्टर अबाउट 20 years. उन्होंने ये कहा जी 96 में जो दी नोटिफिकेशन व्हिच वाज अलाउड टू बी लैप्स्ड.
Let just for a minute.
हाँ जी.
Annexure P1 is the initial order passed in your.
Yes lord.
Let us read that.
Yes ma'am.
कोर्ट ने बोला कि आप
एक्विजिशन करेंगे जी. हाँ जी.
उसके बाद क्या हुआ?
अपील हुई जी.
में गए.
हाँ अपील. हाँ जी.
फिर इन्होंने SLP फाइल की.
SLP में स्लाइट मॉडिफिकेशन.
The order of the honorable Supreme.
Yes ma'am. Lordship, it starts from Annexure P3 page 25 onwards. The relevant is
page 33.
Page 32 में देख लीजिए point 5.1. At this stage, it is required to be noted that in the present case, as such, initially the notification under Section 4 was issued for acquisition of land at village so and so on 17/5/96. This is important, Lord. However, thereafter the notification so issued under Section 4 of the Act was permitted to lapse. Thereafter, on 17/5/1996, can be directed to be treated as a deemed acquisition. Yes, my lord. On that day, and the original landowners may be compensation considering the market price as on 96. However, with all statutory benefits, excluding the interest from 96 till the writ petition was filed before the Honorable High Court, if the aforesaid order is passed in exercise of extraordinary jurisdiction, so and so. Now, Lordship, directing para 6, in view of the above and for the reasons stated above, present appeal stands disposed of directing that 17/5/96 be treated as deemed date of acquisition under section so and so. Now, Lordship, thereafter, Lord, P4 is passed, award is passed. अब इसमें क्या करा जी इन्होंने, जो डीम डेट ऑफ नोटिफिकेशन थी इसमें जी ऊपर लिख दिया डीम्ड अवार्ड ओब्लिक ऑर्डर. हाँ 13/11/24 को
इसके अगेंस्ट
रेफरेंस फाइल किया जी.
एंटरटेन नहीं कर रहे हैं.
इन्होंने ओरिजिनल वापस कर दिया जी कि जी हमने तो सुप्रीम कोर्ट के ऑर्डर को ये.
सर वो तो दैट इज रॉन्ग.
हाँ जी.
मोस्ट अगर रेफरेंस पे सक्सीड करता है,
हाँ जी,
whatever are the bars by the honorable Supreme Court, they will operate.
हाँ that will abide.
They will operate.
I choose the इसमें जी P6 में जो एनोलॉजी जो P6. हाँ जी.
Notice accepts notice Thursday को to enable learned.
Supreme order में ये लिखा है जी कि ये अवार्ड ही नहीं है एज पर दी. हाँ जी. Yes, I am great. Please. Great.
To enable learned AG to have instructions.
Please. Great.
Yes, please. Okay. ये आया नहीं है सर अभी हाली से,
तो थोड़ी सी क्लैरिफिकेशन कर देंगे. वो माय क्लाइंट हैज बीन सिटिंग देयर फॉर द लास्ट 3 days.
वो क्या कह रहे हैं?
वो तहसीलदार साहब से भी बात कराई.
हाँ.
तो उनको पता नहीं लग रहा है कि ये है क्या चीज है. सेक्शन 88 देखेंगे रजिस्टर. सेक्शन 88 एंड 89.
सेक्शन 88
वारंट ऑफ पोजेशन नहीं पहुंचा अभी वहाँ.
यहाँ हाई कोर्ट से नहीं गया है.
हाई कोर्ट से 4 को डिस्पैच हुआ, वहाँ कहते शाम को पहुंचा. ना मेरे को पोजेशन मिल रहा है ना.
इसमें रिप्लाई आ गया है तहसीलदार का? रिप्लाई आ गया. आपको कोई इंस्ट्रक्शंस आई हैं तहसीलदार मनाली से? हैं?
नाम नहीं आ रहा.
आप ऐसे करो सर, इसको मैं परसों रखता हूँ. I direct him to have instruction from तहसीलदार कि what is the status.
इसमें वो 88 देख लें जरा, क्योंकि उसमें करी दे ऑर्डर में भी लिख देना. 88 एंड 89 देखेंगे. तो तहसीलदार से पूछा कैसे होना. वो ये तो डायरेक्शन है कोर्ट की, और 88 89 में ये वो कहते ही सेलर तो है नहीं इसमें. मैं कहा उसकी जरूरत थोड़ी है.
Don't worry, you have instructions by day after tomorrow. Simply pursue it.
लिख ही दे, कोई कर दें. एक हफ्ते के बाद रख दें.
2 दिन देख लेते हैं what he says. Then I'll write the order as you are saying. एक दिन देख लो.
That is the requirement of law.
Don't worry.
Because any certificate issued by the High Court or a registrar.
In terms of the report of the registry, compliance of the order passed by this court on 27th of May 2025 has not been received. Senior counsel for the respondent submits that the decree holder has passed on instructions that
Particularly auction purchaser.
the auction purchaser has passed on the instructions that Tahsildar cum sale officer Manali though has received
Was presented the sale certificate.
was presented the sale certificate on
He was presented on Wednesday को जी किया. It's नहीं Thursday को जी Thursday और Friday 2 दिन हुआ रहा वो.
Thursday को था सर 19 नहीं 12th of June 2025. Full stop. Learned Additional Advocate General is requested to have instructions from Tahsildar cum sale officer Manali as to what has been done in compliance to the order passed by this court on 27th of May 2025.
And also report regarding the warrant of possession which has.
तो ये परसों के लिए मैं सिंपली इतना कर रहा हूँ, फिर मैं परसों डिटेल्ड ऑर्डर पास करूंगा अगर कुछ नहीं होता.
इसको बेशक हफ्ते बाद रख दे क्योंकि वो जो पोजेशन हमारे को दे दे तो द मैटर विल कम टू
मंडे को रख लेते हैं. मंडे.
हाँ ठीक. यहाँ से 4 को गया था वहाँ 13 को पहुंचा. थैंक यू सर.
तो तब तक कुछ नहीं होता, देन आई विल पास एट डिटेल.
ठीक.
ये क्या मैम? एक्सटेंशन ऑफ टाइम.
एक्सटेंशन टाइम की एप्लीकेशन मूव करिए.
We have granted of it, and as far as the rest of the legal is concerned, we are paid.
4 weeks time. Now, लिखना by way of this application, a prayer has been made by the applicant stroke state for grant of 4 weeks time, grant of 4 weeks further time to fully comply the judgment passed by the court. The application is disposed of by granting the state 4 weeks more time to do the needful. Based on dash compliance affidavit. हफ्ते के बाद.
This confusion. I'm not sure whether this application is on record or not.
कौन सी बात?
We have not filed this application for extension of time.
नहीं है ये, तभी उसने तो ऑर्डर पास किया. मिस्टर परमार.
Lordship, I pray for adjournment. Lordship, handle this matter after.
Just 1 minute. मैं आपको 23/5 को दिया हुआ था, महीने से ऊपर हो गया. क्या इंस्ट्रक्शन?
Fact being short possible.
आपका नहीं है सर, एक इंसान. आपने इंस्ट्रक्शन लिखी, क्या इंस्ट्रक्शन है?
लॉर्डशिप मैं था ही नहीं सर, सवेरे पहुंचा मैं.
23/5 को था ना लगा हुआ, क्या है? तो 2 बजे बताओ इंस्ट्रक्शन के पास हो नहीं होंगे ये मैटर. पास हो. फोन करके पूछो क्लाइंट को, 1 महीना हो गया है.
लॉर्डशिप
तो
मैं सर
एक बटन लगा के आया करो, कोई तरीका नहीं होता कोर्ट में आने का.
लॉर्डशिप है.
नहीं, मैं मजाक नहीं कर रहा हूँ. दिस इज नो वे ऑफ अपीयरिंग इन अ कोर्ट. ये कोई फिल्मी कोर्ट थोड़ी चल रहे हैं में होते हैं ऐसे कॉलर यहाँ को निकले हुए. दिस इज नो वे. ठीक है, जाके बटन लगा के आओ पहले. इस साइड कहाँ जा रहा है? सुई धागा है भूपिंदर के पास है. इसको मैं आगे रख देता हूँ, बट नेक्स्ट टाइम आई डोंट वांट टू सी यू लाइक दिस. व्हाट इज दिस नॉनसेंस?
लॉर्डशिप
राइट हो गया कमीज.
लॉर्डशिप मैं सुबह ही पहुंचा हूँ.
एक सेकेंड. रमन, आप कब से कोर्ट में बैठे? कल से. आप कहाँ है? सवेरे कहाँ से आए?
सर मनाली सर ले से.
मैं भी सवेरे ही पहुंचा हूँ अभी सीधा. नहीं, मैं मजाक नहीं कर रहा हूँ. मैं घर भी नहीं गया हूँ, मैं भी सीधा कोर्ट ही आया हूँ और बैठा हूँ. मेरा बटन लगा कि नहीं लगा? फिर दिस इज नो वे. आई एम सीरियसली टेलिंग यू. अगर आप अपनी ड्रेस की रिस्पेक्ट नहीं करोगे ना, इट इज अ रिफ्लेक्शन दैट यू डोंट रिस्पेक्ट योर प्रोफेसर. आई एम टेलिंग यू. इसमें लिखना मिस्टर परमार सबमिट्स दैट ही मे बी ग्रांटेड अ वीक्स मोर टाइम to have instructions in the matter. List on next Monday. बटन लगा क्या? और ये छोटे हो तो 2 साइज बड़ी कमीज खरीदो. और ये पहली बार नहीं है, इसलिए मैंने पॉइंट आउट किया है. यू आर इन द हैबिट. यस प्लीज. इसमें स्टेप्स के लिए दो
ले लिए जी स्टेप्स.
लिखना Mr. Chandel informs the court that appropriate applications to bring on record the legal identities of deceased respondents 10 and 27 have been taken. A registry to place the applications on record if in order.
Lordship.
Yes, please. Mr. Rahi, rejoinder file. Yes, Mr. Rahi.
My lord, this is our execution petition. My lord, may kindly have the judgment at page 8, my lord.
Let us see that.
And relevant para is
केस क्या था सर?
page 8 से start हुई जी. Relevant para is para 9 at page 14, my lord. After hearing the learned counsel for the parties and the entire documents which have come on record, this court finds that the husband of the petitioner was required to be made regular on daily wage basis, as he has completed more than 7 years service as daily wage worker on the date of his death. In these circumstances, the rejection order passed by the respondents concerned is not in consonance with the facts of the present case, as the only ground for rejection is that he has not completed 7 years. Now, my lord, para 11.
Please read it.
In view of the said discussion made herein above, Annexure A17 dated 9th December 2014 is against the factual position, as the husband of the petitioner has completed more than 7 years of service as daily wage basis employee, as he has completed 10 years service as part-time worker and is ordered to be made as daily wage laborer from 1/1/2004 as per his entitlement, as he has completed more than 7 years as daily wage employee, that is 10 years service. He is ordered to be considered as employee having more than 7 years service of daily wage service. In these circumstances, an impugned order dated 9th December 2014 is questioned.
क्या क्या इन्होंने ये
And thereafter, my lord, they have preferred this, they have tested this judgment in LPA.
ये बताओ इन्होंने क्या किया
Now, my lord, in para 3, my lord, of the reply.
में क्या कहते हैं
ये बोल रहे हैं जी that para 3 की third line, in compliance of the court judgment, the respondent department has extended the benefit of daily wage in favor of late series Singh with effect from 1/1/2004 to 8/6/2009 with all consequential benefits, and the differential amount of arrear has been released to the prisoner accordingly. The prisoner Srimati Prabhi Devi is illiterate and is not fulfilled the eligibility criteria for appointment as class 4 in view of the RNP rules of the post. In order to comply the court judgment dated 28th April 2022, her case for employment on compassionate ground was needed to be referred to the finance department for their concurrence, and the finance department advised that.
You see, this is a clear-cut case of contempt. आप contempt है कि execution?
Execution.
How can the finance department support the judgment of the High Court? But why should the High Court not invoke its power of 250? When the High Court, rightly or wrongly, the Honorable Coordinate Bench said that consider him for compassionate appointment. That judgment is upheld by the Division Bench. Still the Finance Department has the audacity to say, are they above this High Court? फिर कभी उनको भी बताया बोला करो ना ऐसे आप जजों को झरकाते हो सारे तो यू शुड परसों चाहिए कंप्लायंस चाहिए मेरे को इसमें लिखना आपने the petitioner herein is aggrieved by the fact that the judgment passed by the court in favor of the petitioner dated 20th of April 2022, directing the respondents to consider the case of the petitioner for grant of appointment on compassionate ground, has still not been abided by. On the pretext that the finance department has advised to the contrary. This court is of the considered view that when there is a mandate by the High Court under Article 226 of the Constitution of India, the finance department has no business to sit over the judgment of the High Court. And this act of the finance department in fact amounts to overreaching the judgment. Overreaching the directions passed by the High Court. Situation, learned Additional Advocate General submits that he may be granted some time to have fresh instructions in the matter. On his request, Thursday. Please. कोई बात don't worry. इसमें लिखना learned Additional Advocate General submits that because of the non-communication of the order at the end of his office, order dated 24/4/2025 could not be complied with. He submits that some more reasonable time be granted to do the legal. 3 weeks. ठीक है? List on dash 4 हफ्ते बाद लगा दो. List on dash compliance affidavit in terms of the previous order. Next. Yes, please, Mr. Nikhil Katwar. Reply not filed.
Your Lordship, I am appearing vice.
Pardon?
I am appearing vice to Advocate Nikhil Katwar.
What is the matter?
Your Lordship, reply was awaited, Your Lordship, as per your last order.
Decide the representation.
Then it can be disclosed with the direction that we will decide with 3 weeks.
शीला देवी आप 23 की है ये कर नहीं रहे. Okay, compliance affidavit not filed 2 weeks. List on that. Compliance affidavit in the meanwhile. Yes, please, Ved Bhushan Sharma.
In this, my lord, the direction is, my lord, at page 12, my lord. Accordingly, the petition is allowed only to the extent that petitioner is held entitled to the benefit of this note from the date of appointment of other income.
Compliance affidavit filed.
No, my lord.
अब भी 1 साल के ऑर्डर है. Compliance affidavit not filed despite reasonable opportunities granted. Weeks list on dash. If compliance affidavit is not filed by the next day, then the officer concerned to remain present in the court to assist the court as to what is the impediment in the compliance of the order passed. Next. Yes, sir.
Please, my lords.
Yes, Mr.
Please, my lords. My lords, this is listed for arguments on various matters. I understand that my learned friend, Mr. Chief and Senior Advocate, has a certain pressing personal emergency in which he needs to leave in half an hour.
Vishal Pawar has lost his mother.
So,
And I'm agreeing to.
Just give me 1 minute. Just 1 minute.
Carrying those replies and rejoinders, they only say a minutes on my 39, 1 and 2. I am not carrying my rejoinder for one reason. It is my contention that the reply cannot come on record due to the delay. Likewise, with respect to the replications for both D4 and D2. The Lords may perhaps have this subject to the court's convenience on 30th, which is certainly Monday.
Well, that's not an issue. But there just 1 minute, Mr. Rajiv. There is one OMP 831 of 25.
That's right, Lord. That is defendant number 4.
Who is appearing for defendant number 4? Aapa? It is beyond 30 and within 120. Okay, within 120. Then we'll keep it on 30th.
It is best.
Okay.
Because I need to show the reasons that India Mart has taken.
Don't worry. You want to file the application 831?
Carrying the replies, because in fact, I carry all of them, we'll file it.
Okay, इसमें लिखना. Pardon? आपने कर देना. You are appearing for R4. मैं R4 की बात कर रहा हूँ. ठीक है, इसमें ऐसे लिख देना. As prayed for list on 30th. ठीक है. In the meanwhile, pleadings in the miscellaneous applications be completed. That will suffice the purpose.
Perhaps no. I also understand. If the Lord only says as prayed for, it will appear as though I am praying for it.
आपके लगा देते हैं राजीव. ले ऐसे नहीं, फिर ऐसे करो. Don't worry. ऐसे लिखते हैं. इसमें लिखना list on 30th of June 2025. In the meanwhile, pleadings in miscellaneous applications, including OMP 831 of 2025, be completed. 831 में लिख देना notice, श्रद्धा accepts notice, है ना? ठीक है सर? Yes, please.
OMP 17, which is my 3912, they have filed a reply, both of D4 and D3, and refraining from filing my rejoinders now. Question on whether the replies of intervention can come on record or not, because I moved the application for closure of the site.
At this stage, learned counsel appearing for the plaintiff submits that the plaintiff be allowed not to file rejoinder to the response filed by the defendants to the application filed under Order 39 Rule 1 and 2.
OMP 17.
OMP 17, sir. 17 of 2024. 2025. For the reason that, according to the plaintiff, the response filed to the said OMP cannot be allowed to be taken on record. submission of Mr. Nataraj is taken on record. It will be taken into consideration by the court on the next day. Next one. Yes, please, Dhanvanti. Reply filed by R1 and R2. Adjournment prayed for. ये क्या sir? Asha Chauhan, HPTDCL. Yes, Mr. Pankaj. Pardon? Reply hasn't. Okay. What is the issue?
The name of the petitioner was promoted to the photo of the by notification 60.
Just 1 minute. Huh? Let us please read para 13 of the judgment. Para 13, page 13, para 13. The petition is the government disposal of the direction because denial of promotion. ओके अब ये जवाब क्या दे रहे हैं प्रमोशन भी दे दिया आपने अब क्या ग्रीवियंस है आपकी मिस्टर भूषण इसमें वो इस केस में नहीं होगा वो तो जस्ट हाँ नो the promotion will be with all consequential benefits. Yes. The consequential benefits. What will be the meaning? No. You see, just 1 minute. Let us take a case that there are 3 stages to which a person can be promoted. 1, 2, 3. Yes. Now, someone comes to the court. With a grievance that I have been wrongly denied the promotion. And the contention of the party is accepted by the court. Let us take a case. आज date क्या है? 16th of June 2025. Directing the respondents to consider the petitioner for promotion from the date when her juniors were promoted with all consequential benefits. Now what happens is, as on 16th of June 2025, when she came to the court, issue was with regard to stage 1. Lekin in the interregnum, those juniors have also been promoted to stage 2. Then how can you say कि हम उसके लिए consider नहीं करेंगे? Are consequential benefits. So if you can demonstrate that the position as on 24th of May 2023 was that there were no further promotions of anyone, then I'll throw the petitioners out of the court. लेकिन अगर 24 मई 2023 से पहले जो जूनियर्स हैं वो स्टेज 1 भी पा गए और स्टेज 2 भी पा गए तो देन ही हैज अ केस मेरी सिर्फ एक रिक्वेस्ट है सिंपल इंग्लिश ये तो हिंदी है मेरे को जस्ट 1 मिनट
Would it within its hold also include all the further channels of promotion which would have
the first thing I was taught as a lawyer was never ask questions to a judge.
No, I'm just thinking
So
situation.
now let us just 1 minute. आप किस पोस्ट पे प्रमोशन मांग रहे थे? हाँ.
In the original petition, the limited prayer was for the promotion to the post of superiority 2.
Mr. Panta, I understand that. Now she was equating her right with which person? With whom?
With the people.
जो भी है. Now when was this?
Who had already marched over and above.
जो मर्जी है.
Only for the post of superiority 2.
I understand that, dear. When were the juniors promoted against the post of superintendent grade 1 or grade 2, whatever the post?
It was private notification dated 2016.
6th of
July
2016. Now demonstrate who were earlier promoted by ignoring the petitioner were given no promotions from the post of superintendent grade 2 as up to 24th of May 2023. Otherwise, today we are in the court of law. कोई 10वीं का पेपर थोड़ी चला हुआ है. No, sorry. No, Mr. Panta. This is not how the system works. Issue is the petitioner comes to the court of law. The court finds favor in the contention of the petitioner. Now, if the petitioner has to be relegated back to the position to which his or her Obviously, consequential benefits will include other promotions also. If those juniors have gained other promotions in the interim.
Absolutely, I'm not averse to
हाँ,
that.
तो फिर-
She has a fundamental right to be
हाँ,
considered
हाँ,
for the purpose of promotion
हाँ,
to that particular.
हाँ.
She has only a right to the extent of being considered. She does not neither have a vested or an indivisible.
Please read the judgment.
Especially,
Please read the judgment.
yes,
The court directed you to promote her.
to promote.
So you have promoted her. You have promoted her. Now the question is, I'm again putting a question to you. Is it your case that as from the year 2016 up to the date when this judgment was delivered by the court, vis-a-vis whom the court granted equity to the petitioner, they were not promoted to the higher level? तो फिर इसको भी करो.
She might be eligible.
नहीं मिस्टर पांडा नहीं ऐसा नहीं है
All that
नहीं नहीं.
issues, can those issues be decided in
Why not? Why not? Why not?
Let him file a separate.
Why?
file a separate,
Why?
pending
No,
or-
sorry, when
this is a
all
separate-
consequential, no. Why not? Consequential benefit. What is the meaning of consequential
Yes,
benefit?
I'm coming to that.
हाँ.
Now, what will happen?
Consequential benefit is a subjective term. It will depend upon the facts of each case as to what will be the consequential benefits.
I do not know whether my.
There is no need. There is no need of a reply.
They had preferred a contempt petition seeking the same relief. The contempt petition was dismissed on the score, on the score that the consequential benefit cannot be determined.
Let us see where is the order.
Kindly, I go to my reply.
दिखाओ जरा.
I don't have the running page number, but I certainly do have the internal.
बताओ. Let us see that.
Kindly go to page number 18. It commences from page number 18 on
Just
the
one
judgment.
minute.
The very first line will
Just 1 minute.
entire issue.
What do you say?
The intent of the judgment has to be.
No, sorry. When you lost the battle in the contempt petition, then how the execution is maintained?
Execution has separate remedy, has a right to petition.
No. Sorry. You see, in fact, Mr. Panta, I'm sorry to say that you are also beating around the bush. मैंने आपको जो query दी थी, बड़ी simple सी query दी. The query has been answered by the honorable coordinate bench.
I wanted to show that.
तो उसके लिए कितना टाइम लगाना था? और लास्ट ओवर में डालनी बॉल. Honorable coordinate bench has been pleased to hold कि कोई promotion ही नहीं हुई है in the interim. तो वो मैंने आपको
In the interview.
ये नहीं है.
But बाद में हुई थी.
बाद after she retired.
Yes.
After she
Yes,
retired.
I was
तो ये नहीं है तो misconceived है आप. Dismissed. मजाक.
That was always available then with them right from the word go.
तभी मैंने आपको बोला ये आप सिंपल सी पहली लाइन बोल देते.
नहीं जी, I just wanted to quote it to this honorable court that the consequential benefits का जो expression है जी उसमें whether the further promotion.
No, sorry. I disagree with you and I strongly disagree with you. Consequential benefits is a subjective term. जो मैंने आपको example दिया था, उसमें consequential benefits will include further promotion offer. Unfortunately for him, for her, honorable coordinate bench in contempt proceedings has categorically held कि जिस दिन petitioner retire हुआ, पहली promotion से उस दिन तक no junior was given any further promotion.
Yes.
तो आपको ये एक लाइन बोलनी चाहिए थी. आप भी फुटेज खा रहे हैं.
इसमें issue यही है कि जो consequential benefits है
In the ऐसे लिखना by way of this execution petition, the petitioner is paying for the execution of the judgment passed by this court in CWP number so and so, title so and so, dated so and so. Mr. Panta has referred to the judgment, has referred to the order passed by the honorable coordinate bench in the contempt proceedings that was initiated as a petitioner. Copy whereof is appended with the reply filed by the responding corporation. Having perused the order passed by the honorable coordinate bench in the contempt proceedings, this court is of the considered view that what the petitioner could not gain in the contempt proceedings, is now being tried to be gained in these proceedings, which is not permissible in the light of the express findings returned by the honorable coordinate bench that that no junior to the petitioner was promoted to the post of superintendent grade 1 till her retirement. Faced with this situation, Mr. Bhushan prays for and is allowed. Mr. Bhushan prays for that that the petitioner be allowed to withdraw this petition with liberty to have access to such remedy as has been ordained by the Honorable Coordinate Bench in the contempt proceeding. The proceedings are closed with liberty. आप रिट फाइल करो, ठीक है. भी मैं आपसे इत्तफाक राय नहीं रखता हूँ. वो जो वर्ड है ना consequential benefits, it will अगर situation होती तो उसमें आना था.
Which enunciate that consequential benefits which will only be limited to the specific directions which had been embodied in the judgment, which is under
in the month of July stroke August 1989. The first lecture I got as a student of law first semester was law is nothing but common sense. So, common sense.
What has happened here was during the interim, they initiated the proceedings for the promotion. Then
but they got stalled. They got stalled. And in fact, the last we initiated that.
ऐसा ना the day the judgment was given, अगर आपको स्टेज जैसे कोर्ट ने बोला था कि आपको एक पर्टिकुलर पोस्ट पे प्रमोशन दी, अगर वो जूनियर्स जिनके साथ आपको कोर्ट ने इक्वेट किया था, अगर जजमेंट से पहले या रिटायरमेंट से पहले या रिटायरमेंट का इशू आ गया, फर्दर प्रमोशन उनको मिलती, आपका राइट था. अब वो हुआ नहीं. अगर वो नहीं हुआ है तो उस पर्टिकुलर प्रमोशन के बेस के ऊपर के क्या आपकी आगे की प्रमोशंस बनती है या नहीं बनती है, वो बेंच ने कहा कि आप सेपरेट प्रोसीडिंग्स में टेस्ट करो. promotion
of promotion, but then all those proceedings were stalled.
ठीक है.
That's a good.
And now in the light of the judgment of the Supreme Court that one cannot come to the court after retirement for promotion.
Yes, I beg to recall that because there is a second house to that. Because that judgment creates a distinction between two different things.
Anyways, yes, Abhishek Sharma. Case क्या है सर? हाँ जी सर. इसमें किया कि नहीं? आज कितने मैटर्स लगे हैं? नहीं, जालम आपके कितने केस हैं? जालम सिंह है ना आपका? जालम सिंह में दे दिए कि नहीं? गुलाब सिंह भी आपका है? अच्छा, गुलाब सिंह में मिल गया कि नहीं मिले आपके इंस्ट्रक्शन के हिसाब से? एरियर्स क्यों नहीं दे रहे हैं? जजमेंट क्या थी? ओके. ठीक है. आप इनमें कंप्लायंस एफिडेविट फाइल करो साहब. हैं? इसमें लिखना ऑन द रिक्वेस्ट ऑफ मिस्टर ठाकुर लिस्ट ऑन डैश 3 हफ्ते के बाद कंप्लायंस एफिडेविट इन द और हर एक में इंडिविजुअल फाइल कर दो. इसमें भी आपने 30 को ऑर्डर पास कर दिया है, बट ये पता नहीं अभी 30/5 को शायद 13/6 को, हाँ पता नहीं पैसे दिए कि नहीं दिए, तो वो कंफर्म करो. भारती सिंगला, मिस्टर आदर्श नया केस है. नोटिस 2 वीक्स में डिसाइड करो. फेलिंग विच 2 वीक्स. है क्या ये? अभिषेक शर्मा. यस डियर. ये क्या है? just one minute. Okay, just come on. Okay, they have decided the representation now. They say, huh? हाँ तो ठीक है, they have a point, they have a logical point there. They say कि हमारी जो आपकी जो पोस्ट है ये डिवीजन लेवल की पोस्ट है, तो you knew very well कि आपका कौन सा डिवीजन है, तो rightly or wrongly if the just 1 minute, if the division is confined to a tribal area, so be it. पसंद नहीं है तो नौकरी छोड़ दो. नहीं, there is no question of fresh representation. इसमें लिखना आपने, आप इसको चैलेंज कर लो. इसमें करना notice accepts notice learned counsel for the respondent has handed over a copy of order dated 1st of April 2025. 1st of April ही है. एक डेट क्या है इसकी? चार एक है कि एक चार है? हाँ? कहाँ से बोल रहे हैं आप 4-1? नहीं नहीं, रिप्रेजेंटेशन मैं इसकी बात कर रहा हूँ. हाँ, क्या 1-4 अप्रैल बना दिया आपने इनका? क्या लिखा आपने? Office order passed by Executive Director Personnel, in terms whereof the representation of the petitioner has been dismissed on the ground that the petitioner was initially appointed as a teammate on contract basis in the year 2021 and posted in electrical subdivision HPSCB Kilar under electrical division HPSCB Kilar district Chamba. Full stop. His services were regularized upon completion of 2 years of uninterrupted service in the year 2023. In terms of the order passed by the authority, the post of teammate is a division cadre post, and in this view of the fact, the petitioner has to be posted in the parent division, which happens to be Kilar district Chamba in the present case. On this count, the representation has been rejected by observing that the transfer of the petitioner outside the electrical division will affect क्या लिखा आपने? On the transfer of the
on this ground, the representation has been rejected by observing that the transfer of petitioner outside the electrical division will affect.
Outside the electrical division is not permissible in law, and if such kind of transfers are allowed, then it will disturb the seniorities which are maintained in the respective divisions, and will give rise to unnecessary litigation. This court finds that the representation of the petitioner has been dismissed by the authority by passing a reasoned order. Therefore, without making any further observation on the office order, this petition is closed, but with liberty to the petitioner that in case the petitioner is agreed by the order, he may assail it in accordance with that. Next. Yes, please. Yes, Mr. Goyal. About 5 rule 20. केस क्या सर ये?
Against the settlement, we had filed an application for correction of the regularity, settlement. That's been demanded twice by the Commission for correcting the.
What is the problem in the service of these two respondents?
From 6 to 9, they were never served. They never appeared before the court to go also. They had sold the property and.
You want to file reply? You say that they are residing there but are avoiding
Yes, even before the court, though they were served to,
दस्ती ले जाओ, अगर कोई रिजाइड कर रहा है दस्ती ले जाओ,
they are not residing at the given.
ये आपने लिखा हुआ है, that the last one applicant
Para 2.
the para 4 पढ़ो ना, are residing at the given address but deliberately avoiding service of some, अगर deliberate कर रहे हैं तो, हाँ?
And they had forwarded to the clients of.
that is a separate issue. That is a separate issue. दस्ती ले जाओ एक बार, हाँ? इसमें लिखना order 5 rule 20 में, having heard learned senior counsel for the applicant, this court is of the considered view that before any order for the substituted service of response 6 to 9 is filed, let an attempt be made by the petitioner to have the said response served दस्ती, ठीक है? Ordered accordingly, दस्ती notice 6 to 9 return for dash. Steps by day after tomorrow, दस्ती notices be handed over to the learned instructing counsel by Friday. 2 हफ्ते के बाद की डेट, अगर फिर देखते उस पर क्या रिपोर्ट आती है? Yes sir. Sir. Okay, no. मैम की रिक्वेस्ट पे after 4 weeks sir. Yes please. ये क्या, where is the learned counsel for the other side sir? Mr. Sood, Miss Sekho आपका केस है? Yes sir.
Registration worship is basically in this case, given worship on 508 of 19, is 209 worship. The word has been made worship, reference is also got of division, and that can be gone to worship create side equation so that the got the money. Question is the claim was more than 1 crore. Was not mentioned over there, therefore we adopt this court.
No, but how do you say that there is no jurisdiction? There was the MSME Act. 209.
Applied on 28th of 19, modified date 29th of 2019. This is the application they applied for.
For being registered under the Act. For being registered under the Act.
Are all right. The question is whether you get this one or you dispute.
Let us see. It is provided in the Act. Let us see that. Section 80 में है ना सर ये?
See the judgment in the Gujarat State Line Corporation of 2020.
No, there is a section in this Act with regard to the registration. वो कौन सा है सर? जिसमें फ्रेश का भी है और जो एग्जिस्टिंग थी उसका भी है. Of section 2. Section 8. Any person who intends to establish a micro or a small may at his discretion.
Micro or a small or a medium, or in the case of a providing services, a small case, then you must need to
When was the dispute raised in this case?
Lordship, in this case, Lordship, what was made by we raised this objection that the claim was a legal control, Lordship. Lordship, that he was Lordship.
Okay, show me the judgment you are referring to, then we'll.
2022 Supreme Court.
2022 AIR
5545.
5545.
And Lordship, I turn to paragraph 33, Lordship. Following the above statement, the party who is not a supplier under the 50 rate of the same flag with the rate of entering the contract would not seek the benefit of the supplier come close to a small price of right pay the benefit of that by submitting a memorandum to pay decision and subsequent entry into a contract supply a good or any service. Many discretion in case of judicial state.
Probably the contention of the senior counsel is that as on the date when the contract was entered into, you are not registered.
We were registered since 2006 under EMI package. Then we migrated in the year 2018 under Udyog Azamana. And then in the year 2020, we migrated under Udyog.
No. Let us see this. When has this act come into force? 2006 Act.
Yes, sir.
Where is the provision of migration?
Migration, it was the provision of migration came in the year 2020.
Where is that? So there is no question. 21 agar migration aaya bhi, it will be.
There was retrospective also. Kindly grant me one opportunity.
No opportunities. The problem is that none of you come prepared.
Kindly have it after some time. Just pass it over. I'll just provide it.
No, there is no. You see. I'll take it up tomorrow.
Yes, ma'am.
है ना, prepare करो आप इसको. अगर jurisdiction का issue है तो है, otherwise the scope is limited.
Second part of it is also we have moved the way we work with this year. He had awarded, but then you point when you were not possible. The claim was 1 crore. Therefore, the objection was they were not mentioned. Therefore, we come to.
That we'll see. Let us first see whether the.
Regarding the jurisdiction.
पहले देख लेते हैं. She's praying for tomorrow. On the request of Mr. कल या परसों कल कितने घंटे में?
Your company is running Russia. So this acted with last petition
No. I have some knowledge as to how this particular act works. So we'll see as to whether they were in a position to invoke the jurisdiction. कल देखते हैं इसको अंदर दिखा देना मेरे को जजमेंट को पैरा 33. Yes, sir. Vidushi. Yes, Mr. Gupta. For impediment, sir. Just 1 minute. Who are you?
We are the person with whom we litigating in respect of same grant.
Okay, notice, sir, accept notice. Reply. Interim to continue. Justice Ajay Sharma, Umar Nandi. Yes, Piyush. So just 1 minute. है क्या issue क्या है? Don't worry.
We follow the three. They granted me development permission. The construction took place. Thereafter, I saw that NOC was also granted. But however, after a period of 2 days of NOC order, they withdrew this NOC grant.
आप बना क्या रहे हैं? Who is the original counsel? कब करना आर्गू? बट इसमें तो आपका वकालतनामा भी तो है, तो करो फिर अभी 2 मिनट बैठो तो सही. बताओ Mr. Piyush, let us see what is the issue. बैठ जाओ, ऐसे नहीं बोलते कहाँ तैयारी की होती है, पर लगना नहीं चाहिए दूसरे को ना. बैठ जाओ आराम से. Yes, please.
This is the sanction plan, my lord. 26 March 2022. Along with this, the plan is also there at Nexus P5.
Yes.
My lord, I have raised construction strictly as per this section plan, my lord, not an inch beyond this plan. Then, my lord, P6, page 38, my lord. I applied for this NOC. Then, my lord, after this NOC, my lord, a notice dated 10/3/22 was issued to me that I am raising construction in violation of. Though, my lord, this is 10/3/22, but it was received by me subsequent to this permission annexure P4. I have responded to this annexure P7, which is annexure P8.
Where is the NOC given wrong?
My lord,
Annexure P12. P12.
P12 is the NOC. My lord, though thereafter the director TCP had stated that this officer did not have the power to review this NOC. Otherwise, as per the act also, my lord, he does not have the power to review. The same applies with only two authorities, and that is subject to certain conditions.
But why have you come to the High Court?
In fact, there I had gone to the secretary by way of an appeal, my lord, my appeal was dismissed.
Where is that order?
Annexure P1, page 20, page 19.
Page 19. Let us see that.
It starts from page 21.
Please do.
The present matter refers to an appeal filed under section 52 of the Himachal Pradesh Town and Country Planning Act 1977, Review Rule 22 of the Himachal Pradesh Town and Country Planning Rules 2014. The appellant is agreed by an order of 22 passed by the Secretary Nagar Panchayat Daulatpur Block, Tehsil Dhanari, District. The three facts of the case as clarified from the office record is that the appellant had submitted the case for planning permission before the Nagar Panchayat Daulatpur Block for double-story commercial building over customer 34 and 56 in Revenue Mahal, Daulatpur through online mode on 3121, having a total plot area of customer 34 and 56 is 424.67 square meters. It has been contended in that the case was proposed at different levels and was approved, and approval was granted conveyed to the appellant of 2022 and under section 31A of the Himachal Pradesh City Act 1977, section 203, SP Municipal Act. Keeping in view of the existing building pattern of Daulatpur planning area, the building was constructed as per approved plan, and there was no addition or alteration at site. Therefore, an NOC was granted on the basis of documents submitted by the appellant at the time of submission of proposal. However, later on, 16/12/22, the appellant submitted an affidavit to NAC Daulatpur Block and admitted that a civil litigation between her and one Shri Sushil Singh is pending before the London Civil Justice Division in respect of demarcation of land, which has been withdrawn by the appellant on 13/5/23. Since the appellant intentionally hides the facts of court case from competent authority, the NEC has withdrawn NOC as granted on 16/12/22. Feeling dissatisfied and agreed of the withdrawal of planning permission, the appellant has filed the present appeal. The appellant had also made a reference to complaint against one Shri Sushil Singh regarding enforcement and unauthorized construction. As per the office report, it is revealed that on dated 26/12/2006, Nagar Panchayat Daulatpur Chowk had approved three-story building having its ground floor as commercial and first and second floor as residential building in favor of Shri Sushil Singh Tower, son of Shri Singh over custom number 25 as per revenue record 93/94 on 26/12/2006, which is 8.56 meter in north and south side and 7.05 in front side and 3 meter balcony in front side. Further on dated 10/5/22, the NAC Daulatpur approved map for additional alteration in existing building of Shri Sushil Singh, then in custom number 31, which is part of custom number 25 in 93/94 revenue record, which shows existing portion of the building 9.90 meter in eastern side and approximately 8.60 meter in height, left and right side, north and south side respectively in the map and addition in ground floor and first floor, backside of the existing building. Presently, she Singh had constructed the structure almost same size as approved by NAC $4 job, except for garage and south side of the by 8.60 meters approximately, and have also cover or extend shops up to the balcony projection. Order dated 28/7/23. Understand during the course of hearing on 28.
Okay, what has happened to this inquiry that was ordered by the principal secretary TCP? So stay hai yahan se. What has happened to the inquiry? You inquire as to what has happened to the inquiry. इसमें you are representing, you are the chugalkhor. He is the chugalkhor. Issue is simple. If I approach an authority and submit a map, and the authority approves the map.
My lord, they after that approval of that map, they have changed the structure. We are.
That is not the finding returned. The finding returned is that the map which was sanctioned by the authorities is in derogation of the provisions of the rules. That is the finding returned by the principal secretary TCP. It is not his finding. Has not strictly followed the permission granted. तो वो कहता है कि बनाया तो मैप के हिसाब से है, लेकिन जो मैप अथॉरिटीज ने अप्रूव किया वो रूल्स के हिसाब से नहीं था. अब अगर मान राइटली और रॉन्गली if someone applies to the authority और अथॉरिटी उसको अप्रूव कर देती है तो फिर नंबर वन. नंबर टू, it is not a case of encroachment etc. आपकी लड़ाई है इसके साथ, आपकी लड़ाई है इसके साथ. चलिए.
In fact, my lord, the chairman's relative is next to me. There was litigation against him. He has raised construction like difficult for me. This is in nutshell.
ये तो कुछ है नहीं इसमें जान. आप इससे दोस्ती क्यों नहीं कर लेते?
दोस्ती की तो कोई बात ही नहीं.
Buy peace with them. Buy हैं? क्योंकि प्रॉब्लम ये है, it appears that you are co-owners of the land. नहीं तो फिर ये पार्टीशन वगैरह का क्या पंगा है? वो किसी और के साथ है. वो कोर्ट में है ही नहीं. कौन है तू?
मैं तो नगर पंचायत
नहीं, शिकायत करता कौन है? आप तो इनके दोस्त हैं, आप तो बैठ जाओ आराम से. शिकायत करता कौन है? Who is the person who raised the?
In fact, they are not happy with that. That I know. Yes. But there was litigation with the neighbor who happens to be related to the chairman of this NAC.
पहले आप इंक्वायरी का बताओ मेरे को. हाँ, इंक्वायरी का इसमें लिखना on the request of Mr. Sharma, list after 3 weeks. List on dash 3 हफ्ते के बाद लगा दो. In the meantime, learned additional advocate general to have instructions as to whether an inquiry has been held in terms of the order passed by principal secretary TCP है सर ये? Principal secretary TCP, and if yes, then the fate thereof. चलो ये देख लेना, ये इंक्वायरी रिपोर्ट अप्रूव ना होनी हो कहीं से, वो पहले कर लेना सारे. ठीक है ना? Yes, Raman. Rejoinder file. Okay. So why are they not giving?
They are not giving, Your Lordship. In fact, what had happened? 6 landowners who have already approved from the Supreme Court and orders that they passed in their favor, Your Lordship. Now they are saying that since they have approved and you have not approved, you cannot be the beneficiary of that judgment. This is the reply which has been filed by them.
How do you respond to that?
Your Lordship, I have responded because even if the person has not gone to the court, Your Lordship, they are also.
ये तो इक्विटी, ये तो लैंड तो एक्वायर हुई है इसकी भी. तो whatever you see, basic अगर basic principle है that one is entitled to the best price. वो जैसे मर्जी अराइव किया हो. So अगर best price is on the basis of some adjudication between you and the other owners whose land has been utilized for sale, दे दो. कितना मिलना है?
Approximately, Your Lordship, as per calculation,
1.5 crore. पर पहले इनसे एफिडेविट लेना लंदन नहीं जाएगा घूमने, है ना? पैरिटी पे तो देना पड़ेगा देन। आप देख लो फिर इसको, विल डिसाइड इट। अगर करना है तो बताओ, कर दें डिसाइड। आप बोलो, लेट अस सी व्हाट इज द इशू। नेक्स्ट P11 को आप कॉश करना चाहते हो, लेट अस। हाँ,
I have, because other corners, they have approved the reference code, Your Lordship. I have approved the learned land acquisition collector because the order was passed by him, Your Lordship, under section 2018. Now the order which has been passed, Your Lordship, kindly see at page 20,
P11, yes.
And
Let us read that.
Your Lordship, relevant would be at page 118, para 16 at the bottom. Careful examination of here.
Please read.
Above order shows that these orders simply provide equitable treatment to all co-owners of the expired land for which a favorable award is earned through a reference, and this order does not in any manner encourage condonation in ordinary delays in seeking the reference. Further, the present applicants are not co-owners of the beneficiary landowners of 2016 order of the Honorable Supreme Court, are simply landowners covered under the same.
Okay, will ठीक है, इसको आप दोनों साइड आप भी देख लो इसको। Will I'll hear it on merit. अगर if there is an order passed, if the authority has applied its mind, then we'll go into it. ठीक है?
Because on one side they are saying that we are not the beneficiary, and on the other side they are saying that the land has been acquired with the same notification. It is a part of same notification acquisition.
That is true. But if you were not vigilant of your rights, then if you are not vigilant of your rights, then
because that's why in fact in the execution also this, because that notification has been from the Supreme Court.
Then also no question is not this. Question is that Honorable Supreme Court has been pleased to decide a list which went to the Honorable Supreme Court because someone took the cudgels of initiating it. आपने नहीं की है तो फिर हाँ तो वो दिखाओ, वो देखनी पड़ेगी, है ना? हाँ हाँ, सुप्रीम कोर्ट दिखाओ। डोंट वरी, साइटेशन दो रमन है तो है।
It is Your Lordship 2017. 2019 volume 9 SCC page 416.
2019 volume 9 SCC
page 416.
Page 416. So that on the next date of hearing, your friend can also have the benefit of these judgments. Right? Four 116. Yes.
I'm sorry, Your Lordship, this was regarding
ये तो clerical error के है।
2017 volume 9 page 426.
17 का नहीं,
17 का
page
426.
दे दो मेरे को, दे दो।
Para 8
दे दो।
at page 434.
426 ना सर?
Yes, sir. At page 434.
Please read.
The purpose and objective behind the aforesaid provision is sanitary in nature. It is kept in mind that those landowners who are agriculturists in most of the cases and whose land is acquired for public purpose should get fair compensation.
This is what I was observing at the first instance.
Yes.
That the purpose, that the rationale is that you have to give the best price.
Yes.
How that price is achieved at,
Yes.
it is not all that material.
Yes.
It is not all that material.
Then further,
No, I've read it up.
once a particular rate of compensation is judicially determined, which becomes a fair compensation, benefit thereof is to be given
Even to those who could not approach the court.
It is with this aim the provision is incorporated in the legislation. Once we process purpose in mind.
But इसमें भी 28A का भी एक पर इसका पर आपका इसको एक जवाब देना पड़ेगा। 28A, there is a time period prescribed within which you have to.
Your Lordship, this was not 28. This was not 28 has already been adjudicated. The authority
नहीं
has-
मैं कह रहा हूँ 20 बेसिक जो statutory provision है, that is 28A. 28A may be party within a particular time has to come.
I forgive you, Lordship, in fact, I was in execution.
Huh.
I was in execution. 28A has already been decided. Amount has already been adjudicated, Your Lordship.
Okay.
This is the amount which has been given by the Honorable Supreme Court from the date of taking possession till 15%. by way of
Okay.
penalty.
Okay.
So this damages. has
Okay.
been
This is additional amount.
additional amount.
Okay.
So I'm claiming that.
So you are only claiming that that additional amount which now stands adjudicated
Yes, Your Lord.
should be given to us also.
Yes. So 6 landowners they have already given.
Given. Okay.
In 2009.
आप एक हफ्ते का टाइम दे देते हैं. Heard in part. List for continuation on. This is 2017. 2017 वॉल्यूम 9 SCC पेज 426. ठीक है, कोई बात नहीं. मंडे, नेक्स्ट मंडे. हाँ, ओके. श्री अजय ठाकुर. What is the order passed by the court, ma'am? Taj Muhammad. Okay. Reply not filed, 3 weeks list on dash. Failing which officer concerned to remain present in the court to show cause as to why appropriate action be not taken for willful disobedience of the directions passed by the court. Yes, please, Ms. Ashish. Yes, please. Case क्या है? What is the case? Non चंबावाड़ा case. Where was the petitioner born? Delhi. His place of birth is Delhi. आपको ना ये देखना पड़ेगा, ये जो 1/8/2022 की इंस्ट्रक्शंस है, हैव यू गॉट अ कॉपी देयर ऑफ? उसमें पढ़ो प्लीज, आपके हिसाब से आप किस क्लॉज में फिट होते हैं. राशन कार्ड, एम्प्लॉयमेंट सर्टिफिकेट, ये डेट ऑफ बर्थ सर्टिफिकेट नहीं है. परिवार रजिस्टर शोइंग द प्लेस ऑफ रेजिडेंस ऑफ द एप्लीकेंट एंड रिफ्लेक्टिंग द एप्लीकेंट फॉर द लास्ट 20 years, वो भी नहीं लगता. आधार कार्ड, वोटर कार्ड 20 years, revenue record showing the applicant continuously 20 years, Kisan book issued by Panchayat so and so 20 years, certificate issued by class 2 gazetted officer working under the 20 years. इसमें नहीं आप फॉल कर पाएंगे. हाँ, इसको आप बताओ जरा केस क्या है, बताओ. हैं? वो किसके लिए है? आप 2 मिनट बैठो अरुण. यस. You see, if you come to page 31 of the paper book, please see page 31. The Honorable High Court of Himachal Pradesh in its judgment dated 13/10/20, Division Bench in CWP number has been pleased to order before the concerned authority for its Now, इससे आप कैसे रिगल आउट करेंगे?
On one hand, they are issuing me agriculture certificate. I have annexed Jamavanti of the state, which is also reflected in my name. Okay. Certificate issued by the Pradhan of my mother's side, Gram Panchayat.
You see, मैं आपको वैसे बताता हूँ. Big industrial houses of India, they own big orchards in district Kullu. I personally know. सबके वहां पे orchards हैं. They are all agriculturists because they own orchards in the state. Can they be said to be bona fide Himachalis? क्योंकि agriculturist certificate एक चीज है. If I own a piece of land, agricultural land in Himachal, but by God's grace, कहाँ रहना? मैं बाहर जा रहा हूँ. कौन सी कंट्री पसंद है? कौन सी कंट्री पसंद है? मैं आपसे पूछ रहा हूँ. हाँ तो फिर चलो. Let us assume you are residing somewhere outside India. I am not saying that मेरी अपनी reservations हैं, but when there is a judgment of the Honorable Division Bench, and Honorable Division Bench ने parameters दे दिए हुए हैं, जिसको इन्होंने एक instruction में convert किया हुआ है, then I cannot go outside that. That is the problem. तो इसका dismissal लो और LPA में जाओ. नहीं, राशन कार्ड है आपके पास? नहीं, आधार नहीं भाई, राशन कार्ड. राशन कार्ड चाहिए. राशन कार्ड चाहिए. एम्प्लॉयमेंट सर्टिफिकेट शोइंग दैट यू आर वर्किंग फॉर द लास्ट 20 years. डेट ऑफ बर्थ भी नहीं है आपका. Just give me 1 minute. इसमें ना वैसे अब what has been done by the legislation per se, जबकि वो आपका जॉब है. Assuming कि आपने एक HPMC का बूथ खोल दिया बॉम्बे में, ठीक है ना जी, वहां पे आप अपना 7-in-1 बेच रहे हो, और दो बेचारे यहाँ से बंदे उठाए और उनको बॉम्बे पोस्ट कर दिया, और वो 30 साल से आपके वहां पे काम कर रहे हैं. उनके बच्चे जो हैं they can't be bona fide Himachalis. हाँ, I know that. I've heard. They can't be bona fide Himachalis. और उसकी क्या गलती है बच्चे की? वो पढ़ने भी नहीं गया, हो तो माँ बाप के साथ गया. माँ बाप जूस बेच रहे हैं. And in this case, if I recollect the facts, जो बच्चे की मदर है, she was a disabled lady. तो इसलिए वो she left Chamba. हाँ, तो they were special. फिर वो बेचारे बाहर गए. दिल्ली में उन्होंने अपनी रोजी रोटी कमाई, बच्चा वहाँ पढ़ा लिखा. Now the state disowns him, and for the purpose of education. हाँ, हाँ, थोड़ा सा ना इसमें फ्लॉ है थोड़ा सा. हाँ, नहीं, एग्रीकल्चर सर्टिफिकेट तो मैंने आपको बोला ना, इफ यू ओन एग्रीकल्चरल लैंड इन हिमाचल यू आर एंटाइटल्ड. क्योंकि हम सबको ये गलत फहमी है कि एग्रीकल्चरिस्ट होने के लिए हिमाचली होना जरूरी है. वो नहीं है. इफ समवन ओन्स एग्रीकल्चरल लैंड हियर, ही इज एन एग्रीकल्चरिस्ट. बट यहाँ पे आई एम अगेन सेइंग दैट इट इज ऑन अकाउंट ऑफ द कंडीशंस व्हिच वाज. चलो इसको ऐसे करो, इसमें लिखो, learned additional advocate general has handed over a copy of instructions issued by the state in terms of order dated 27/5/2025 which are taken on record. Now list for further consideration next Wednesday को. Yes, please. Mehta Transport. Yes, ma'am. अब ये 2 बजे रखना था ना नहीं रिकॉर्ड आ गया इसमें विल हियर इट एट 2 PM सर है ना 2 बजे सुनिए आप देख लेना रिकॉर्ड देख
It's at 2 PM.
जस्ट 1 minute sir how much time will it we'll take it after that Mr. Agarwal will join at around 2:30 sir
Please, your lordship. Please, your lordship.
2:30 Mr. Kaushal ये क्या है इसमें रिजॉइंडर भी नहीं फाइल किया रिजॉइंडर तो फाइल किया हाँ हाँ आप कौन है Who are you? When will Mr. Kaushal?
This electricity report may be directed to place on record is electricity consumption.
Just one minute. No, but the court has granted status quo.
Status quo, Your Lordship. When Your Lordship, now Your Lordship's permission that ended 2020, Your Lordship. Lordship,
how are you running the crusher if there is no annexure P5?
There was P5, P29, Your Lordship. But this was
just one. No, but yeah, why did he come to the court in 24?
Your Lordship, actually permission is not being given to him.
Just one minute. What was the interim period for in the application?
Status quo, Your Lordship.
नहीं. Application. Just one. जो 151 की application थी ना जिसमें status quo का order हुआ.
Annexure P5 and P7 will stay, Your Lordship. Disconnection के order आगे थे.
Just 1 minute. No, you see, when he came specifically against the act of the respondents of disconnecting his electricity. Honorable coordinate bench has been pleased to pass status quo order. So, but natural, he will be consuming electricity. No. Status quo vis-a-vis the electricity. हाँ.
No right to run an illegal stone crusher.
वो नहीं है, वो तो decide करे. That the court will decide. But 2 हफ्ते के बाद I will, ठीक है? Request has been made. इसमें ऐसे लिखना on the request of learned counsel for the petitioner based on dash as he submits that learned senior counsel to argue his case is not available on account of the ill health of his mother. 2 हफ्ते के बाद डेट ठीक है interim to yes Miss Dhiman Mr. R.L. चौधरी साहब ये क्या सर नहीं आपका ग्रीवियंस क्या है इंक्वायरी इन द मैटर ऑफ डिसेबिलिटी है आपके हिसाब से गलत लिया हुआ इन्होंने ये ओके व्हाट इज द स्टैंड ऑफ द रिस्पोंडेंट्स हाँ इट इज सबमिटेड दैट
issued online after the assessment by the fixed by the district medical board as constituted to assess the disability of the candidate on every working Sunday on the prescribed format against the proper disability. The proper medical board was there. They have issued the medical certificate. And my lord, this certificate has only been signed by the same. That is the certificate of the candidate on every working Sunday on the prescribed format against the proper medical board. The proper medical board was there. They have issued the medical certificate. And my lord, this certificate has only been signed by the same.
And as per the policy manual, which is on the record, the joiner.
नहीं, इसमें एक चीज है, I will direct them to hold a medical board, constitute a medical board and have this person examined. रिपोर्ट आ जाएगी कोर्ट में, लेकिन इस चीज का ध्यान रखना, if the report is if the report goes against you, मैं 5 लाख रुपया कॉस्ट डालूंगा, because the allegation in the reply is that this is a motivated litigation for the reason कि ये जो जिसके आप पीछे पड़े हैं वो किसी केस में आपके खिलाफ उसने गवाही दी हुई। नहीं, चौधरी साहब कहते हैं ना, हाथ कंगन को आरसी क्या पढ़े लिखे को फारसी, तो करा लो उसका एग्जामिनेशन, ठीक है। 5 लाख कॉस्ट में ऑर्डर में लिखूंगा। नहीं, मैं सच्चे, और अगर ये हुआ तो फिर प्राइवेट पार्टी को से वसूल करेंगे। नहीं, स्टेटमेंट थोड़ी मैं ले रहा हूँ आपकी, मैं तो ऑर्डर में लिखूंगा। चलो मैं ये नहीं लिखूंगा, पर आपको, पर यू हैव टू बी प्रिपेयर्ड, मैं वैसे ही कह रहा हूँ, द पिटिशनर हैज टू बी प्रिपेयर्ड कि द मेडिकल, यू सी, मेडिकल रिपोर्ट में ना आप एक्सपर्ट है ना मैं एक्सपर्ट।
स्टेट गवर्नमेंट ने बुलाया, इसमें 3 बंदे बैठे।
क्वेश्चन इज नॉट दिस, क्वेश्चन इज नॉट दिस, क्वेश्चन ये नहीं है। क्वेश्चन ये है कि if there is a certificate to the effect that person is Amitabh Bachchan and he actually is Amitabh Bachchan, तो आपका कोर्ट में ये आके कहना कि जो इसको सर्टिफिकेट दिया हुआ है declaring him to be Amitabh Bachchan, it is bad, whether it will be having any merit or not, क्योंकि court will entertain you only if your allegation is that this person has been able to procure there is a disabled person, whereas he does not suffer from any such disability.
What is these certificates of this contrary to the notification?
Mr. Chaudhary, अंग्रेजी में कहावत है, look who's talking. What are the credentials of the petitioner? और जो प्राइवेट रिस्पोंडेंट हो, मेरे को लगता है क्लास 4 एम्प्लॉई हैं।
नहीं, ये जो my lord has which is 17, this petition filed a complaint that this certificate has been issued.
नहीं, मैं कुछ और कह रहा हूँ। प्राइवेट रिस्पोंडेंट क्या क्लास 4 एम्प्लॉई है? जिस हाँ, तो ये क्लास 4 एम्प्लॉई है। नहीं, संजय कुमार कौन है?
Sanjay Kumar is a person of one class 4 who is working in CNO office, and this Naxal P3 was also issued by the chief medical officer.
Sir, sorry, no jalebis. Who is respondent number 4? He is the person who, according to you, has obtained the job on the basis of a false certificate. हाँ, आप ये लिखो ना, पढ़ो।
Wife of the respondent serving as
हाँ, wife of the sir, okay, in the hospital named so and so, and as a result forgery she got issued a disability certificate to her husband Sanjay Kumar, private respondent. ठीक है, you are right. Wife उसकी क्लास 4 एम्प्लॉई है जिसने अपने इन्फ्लुएंस यूज करके किसको सर्टिफिकेट दिला दिया डिसेबिलिटी। हाँ, तो करा देते हैं मेडिकल बोर्ड। हाँ, फिर इसने इस सर्टिफिकेट से किया क्या? कुछ भी नहीं किया। तो आपका लोकस क्या हुआ? Who are you? If the certificate, so-called certificate, which has not been issued as per the process, has not been used or abused, what is the locus of the petitioner? और यहाँ पे अभी आपने बोला कि यहाँ पे बड़े भारी सर्टिफिकेट ऐसे इशू हो रहे हैं। Again, who is the petitioner?
Petitioner is also this service is resident of that area.
हाँ,
But you know, file it.
हाँ,
हाँ, this was argued earlier at lunch, and they almost told you that if it has not been issued in terms of the policy, this certificate is back.
How are you bothered? मेरे को एक चीज समझ नहीं है. How are you bothered? Can any Tom, Dick and Harry come to the court? I can understand that you एक particular job के लिए आपने अप्लाई किया, उसने भी अप्लाई किया, and there you doubt the credentials of the certificate or the credentials of the person. इंस्ट्रक्शन क्या लेनी है? कर रहा हूँ इसको मेडिकल बोर्ड को, अगर ये बंदा मेडिकली डिसेबल्ड है तो फिर द पिटिशनर विल पे द प्राइवेट रिस्पोंडेंट, और अगर गलत है तो नहीं है तो ठीक है, मैं कर लूँ। हाँ ठीक है, इसमें लिखना आपने the moot issue involved in this writ petition is with regard to the veracity of the disability certificate which has been issued to the private respondent. According to the petitioner, the certificate was issued in favor of the private respondent as a result of forgery, within inverted comma likhna, forgery, comma, perjury and misrepresentation, as also a conspiracy hatched by the wife of the private respondent, who incidentally has not been added as a party respondent in the petition, comma, with respondent number 3. क्लास 4 स्वीपर जो है वो एक सीएमओ के साथ कंस्पायर कर रही है। In order to ascertain this fact as to whether the private respondent indeed is a person who suffers from physical disability is difficulty. नहीं, आपको क्या लेना देना? Then I am asking you, what is your locus? What is your locus? More so when the certificate has not been used by the person till date. What is your locus? हाँ, locus बताओ, वरना मैं वैसे dismiss करूँगा with cost. This is sheer wastage of the time of the court. नहीं, ना भी करें, ये तो आपके पास फर्स्ट ही केस ऐसे हैं, आपकी भी गलती नहीं है। This, at least I'm not going to encourage this kind of litigation. Genuine बंदा है, आए, court will, I will pass over 2 बजे 2 PM. Yes, ma'am. R2 served. What was the matter, ma'am? आप आ रहे हैं? You are appearing for respond number? Number 1. And who is appearing for number 2? What is the matter?
The respondent number 1 had filed a claim for the labor tribunal, wherein they had violation of that her services were terminated in violation of section 25F, 25H and 25G.
Okay.
As far as 25H and 25G are concerned, your lordship, the labor court has pointed out that there is no violation because neither the names of the people who were employed as fresh hands have been given, and neither the details of the juniors who were retained was given.
Record आ गया इसमें?
As far as your lordship 25 concerned, your lordship, the learned labor court from the tribunal has returned finding against me, and your lordship, in fact, in the reply, I pointed it out that the person is the employee of the contractor, your lordship, and not my employee, and it is there in their claim petition as well. However, they've held me liable and they've asked me to take
record. Just record आया हुआ है? इसमें ऐसे लिखना, respondent number 2 stands served as none has put in appearance on behalf of the said respondent despite service proceed against ex parties. List for consideration on dash जुलाई की डेट दे दीजिए, registry to ensure that the record from the labor court is received by the next day. Record आने दो, फिर देखते हैं। जुलाई Okay, no problem, no problem. Yes.
appears the petitioner in person, Lordship. This is why I'm not on my full ropes.
No, that's not an issue. R9 served.
I'm sorry,
R9 served.
Your Honor, completely the oversight, Your Lordship, process could not be filed, Your Honor. I'll request.
नहीं वो सर्विस हो गई है.
9 is served.
हाँ 9 by way of a fixation. Number 9. So then your purpose is served. Okay, just a minute. Okay, इसमें लिखना आपने Mr. Thakur has put in appearance on behalf of respondent number 9. वकालतनामा within?
4 weeks.
नहीं वकालतनामा. वकालतनामे के लिए 4 हफ्ते नहीं.
In fact, they are getting every day, my lord.
Vaka-
They have to focus dialysis, my lord. If patient.
वकालतनामा तो
I'll try, my lord.
वकालतनामा within 1 week.
1 week,
2 weeks. Reply बाकियों ने कर दिया reply file.
So, Your Honor, so far as private respondents 6 to 8 are concerned,
हाँ,
Lordship,
हाँ.
they have already vacated the premises which was under their occupations with Lordship, so nothing survives against 6 to 8.
Okay,
So they
okay.
may be ordered to be deleted from the area of parties.
Okay, just 1 minute. Reply by respondent number 9 within 4 weeks list on dash. 4 हफ्ते के बाद.
That's the copy of the petition.
वो कॉपी दे देना. Petitioner undertakes to supply a complete paper book to the learned counsel appearing for respondent number 9 during the course of the dates. At this stage, the petitioner has made a statement in the court that as respondent 6 to 8 have vacated the premises and there's now no cause survives against them, their names be deleted from the area of respondents. Ordered accordingly. हाँ हाँ आपने क्या इंस्ट्रक्शन दी?
6 to 8, Lordship, the private respondents, Lordship, there was a possession suit which the petitioner had filed against.
What is this writ petition?
This is Lordship, the premises, there's a building in honor,
Just
which has been declared as unsafe and unfit for human habitation.
हाँ.
So basis that, Lordship, respondent number 2 had issued notice to the petitioner and also the private respondents to vacate and demolish the building in honor.
इसमें आपके खिलाफ कौन बचे? 6 से 8 आप हैं. आपको क्या जब वो खुद बोल रहे तो आप जाओ. You should be more than happy. The instructions क्या? I'm directing that you are deleted. आप no order adverse to your interest can be passed. No order. बोलो डरो मत.
Just to state the facts, Lordship, the petitioner had filed a possession.
Okay, no problem. ऐसे let us encourage our young friends. इसमें therefore now there is no cause surviving. This court, the contention of the petitioner shall be taken into consideration on the next date of hearing. 4 हफ्ते के बाद टाइम.
अब आप Lordship for an action date.
हाँ actual date. When do you want?
Mid-October if possible.
October.
If possible.
You don't want to.
Delhi, Lordship. I'm not.
1 minute. No, October नहीं. I'll give you a date in the month of July. Take 28th of July. That is a Monday.
If Tuesday if possible.
Tuesday लेना. 29th लेना. Yes, please. Mr. Rajaram Rahi. Yes, Mr. Rahi. Without payment of compensation? Okay. What is this response? Para?
That the ownership of this good land rests with the.
Just 1 minute. Who is the petitioner? Pyar Chand. Okay. Description of land. 0-5 मर्रा. खाता खतौनी नंबर खसरा नंबर 104 105 so the land.
After the
हाँ मैंने देख लिया वो. If the stand of the state is that the land was duly acquired in the year 1969, then what is the worth of the sale deed entered into in the year 1992? हाँ.
When this land was transferred in the name of the state.
हाँ.
This call number 4.
हाँ.
To Trustee Bhatt, this Trustee Bhatt, Uttar Srimati Consultation, Trustee Bhatt, area. No, my lord, they kindly happen, no, my lord. This Mukama Mitu, I no government,
Mr. Rahi, award rightly or wrongly was passed in the year 1974.
So, my lord, this land, so allow जो मरला थे ना जी, वो नहीं था.
0-5 बरला. बताओ.
My lord, they kindly have this.
Okay.
At page 22, and this column 104 at page 23, 104 This is Martha.
No. You see, I fail to understand one thing. When, according to you, the land was utilized for the purpose of construction of road. When, according to you?
They have started in the year 1972.
सर ऐसा है ना, मेरे सवाल का जवाब दो. आपने 0-5 मरले जमीन खरीदी 92 में. अगर आप कोर्ट में आ रहे हैं, demonstrate that that particular piece of land was utilized by the state after 1992. अगर आपने कोई ऐसी चीज खरीद ली है जिसकी ना मलकियत थी ना जिसका कब्जा था किसी के पास, तो फिर सर मेरे को नहीं पता. Where is your allegation in the writ petition that this particular land which was purchased by you in the year 1992 was utilized by them after you had purchased this? Otherwise इसमें दिक्कत है. These are disputed issues. Go to the civil court. हाई कोर्ट का काम नहीं होगा. I'm not saying कि आपकी grievance genuine है या नहीं है, लेकिन फिर disputed issues हो जाते हैं. Go तो फिर then go to the civil court. नीचे फाइट करो, यहाँ पे नहीं बनेगा. Withdraw it with liberty, मैं liberty दे देता हूँ. क्या कहते हैं? हाई कोर्ट का काम नहीं है. This is not the job of the high court. Lead evidence. इसमें ऐसे लिखना, by way of this writ petition, the petitioner has paid for the following reliefs. The contention of the petition, the land description whereof is given in the writ petition was purchased by the petitioner by way of a duly registered sale deed in the year 1992, and the same stands utilized by the state without compensating the petitioner in accordance with law. In terms of the reply filed by the state, the land was acquired in the year 1969, and award was also passed in the year 1974. Learned Deputy Advocate General submits that the land was acquired in accordance with law, including the land purportedly purchased by the petitioner in the year 1992, and the rightful owners of the land were as in the year 1974, and therefore the petitioner has no locus to file and maintain this petition. This is seriously disputed by the learned counsel appearing for the petitioner, who submits that the petitioner that when the petitioner purchased the land in the year 1992, the property was there, and the same has been illegally utilized by the state without compensating the petitioner. Having heard learned counsel for the petitioner as well as learned Deputy Advocate General, this is considered that as there are seriously disputed questions of law involved in this petition, which can be decided only on the basis of the evidence that may be led by the parties in support of their respective contentions. The matter cannot be adjudicated by this court in its writ jurisdiction. At this stage, learned counsel for the petitioner prays for permission to withdraw the petition with liberty to the petitioners to invoke the jurisdiction of the civil court is to advise. Yes, sir.
Yes, ma'am.
Yes, please. What is the matter, sir?
Yes, ma'am. I know we are the contractors, we did overworks for the state of Himachal Pradesh. Despite completion certificate, performance certificate.
They are not paying you.
Not paying you, and their denial is based upon a document which itself is not correct.
Okay, when do you want it?
Yes, otherwise,
नहीं, when do you want it? आप कह रहे हैं कि you want
I
it.
am seeking a judgment because my lord has already given judgment that the contractual.
No, you see, that is one thing. Secondly, what I'm doing now is that if the other party is saying that okay, we admit, assuming you come to the court, 10 crore रोके हुए हैं. The state says कि नहीं 3 crore बनते हैं. So what my personal view is that undisputed
This is
amount.
not their issue.
हाँ.
They are relying upon a document, page 24 of their reply.
हाँ.
The entire denial is on that basis, and which is
Reply.
page 24 of their reply in writ number 757.
How many cases are there today?
2 cases, the third case is not listing because reply has not been filed.
20, page 24, 25, sir.
24.
24,
Of
yes.
their reply.
Yes.
My lords, in the bottom, a handwritten writing is there.
All measurements.
Yes, a certificate, the word certificate is there. May I read from there?
हाँ. Certificate.
Certified that the work has been done as per
More.
specifications, and next paragraph, my lord, certified that nothing is
Due.
due from the contractor. From the contractor, my lords. Not, it is a different meaning.
No,
It
no,
means I have done.
no, that's not the issue. Issue is who is the authority? Who is the authority which takes the final call? I'm not aware. मैं आपसे पूछ रहा हूँ. Which is the authority that takes the final?
Executive engineer needs to be addressed. Yes.
क्योंकि ये जो आपने पढ़ा ना सर, ये है जेई ने किया हुआ.
Yes.
This is the noting of the junior engineer.
Yes, my lord. And state is relying only upon this document. There nothing is due against them. Whereas this document says nothing is from my side.
तो ये तो कहता है कि nothing is due from the contractor.
Yes.
ये नहीं कहता nothing is due to the contractor.
Yes.
आप इसमें instructions लो. हाँ, अगर हाँ, you are the person who has to pay. नहीं तो आपने काम किसका एग्जीक्यूट किया?
No, the project was in collaboration with the state of Himachal.
हाँ.
Tender issued by.
आप क्या कह रहे हो? Nothing is due to him कि nothing is due to him from you? किसने? सारी पेमेंटें होगी हुई हैं?
Because they are claiming some all are disputed facts.
हाँ. पहले मेरे को आप ये बताओ ना, आपका लोकस क्या है? मैं इसलिए पूछ रहा हूँ.
I do agree,
हाँ.
अगर इनका कोई बीच का है तो मैं instructions ले लेता हूँ.
नहीं, आप हो कौन? पहले मेरे को ये बताओ.
Union of India Minister of Road
मिनिस्ट्री ऑफ रोड ट्रांसफर. हाँ?
Transport.
पेमेंट किसने करनी है? पेमेंट किसने करनी है? पेमेंट स्टेट ने करनी है कि आपने करनी है?
स्टेट को हम दें.
स्टेट को आप देंगे.
ये बिल रेज करेंगे.
हाँ, मैं समझ गया.
हमारे पास देंगे. अगर उसमें कोई
ओके, व्हाट डू आप जो मेरी जजमेंट का जिक्र कर रहे थे उसका क्या है?
That was challenged before the division.
हाँ.
Division disposed of.
हाँ.
Judgment has not uploaded, but I came to know
हाँ.
that the division bench stated that there is no representation or legal notice served.
हाँ.
Matter was not maintainable.
हाँ.
So you first serve a legal notice to the authority.
हाँ.
We will decide this issue of maintainability later on.
ओके, तो विल वेट.
No, that
हाँ.
matter is being disposed of.
हाँ.
I am having another judgment of this honorable High Court,
हाँ.
the division bench, in the similar matter,
हाँ.
where
No, I know that.
partial relief is
हाँ,
also
part
given,
हाँ.
as well as some arbitrariness is also being appointed. Paragraph 8. But some factual differences are there in this case, and this is my case. Paragraph 8 and 10, 10 is also important. In my case, completion certificate is there, performance certificate is there.
Only problem is that in the light of the respective contention of the parties, how can the High Court under 226 if things are under dispute? That is the problem.
I have given a table of payment, they have not denied that. In fact,
हाँ. हाँ. हाँ.
but one thing can be done.
हाँ.
The J&K Himachal High Court, the J&K High Court have done that. I will show that.
हाँ. हाँ.
Need one.
हाँ. What has been done?
Yes, my lord. State level inquiry committee is being.
No, I'm not going to do that. You may go to the appropriate fora for the adjudication. You see, let us take a case. I'm again saying that I'm also aware that now what the state government is doing is कि when I passed that order जो मैंने पास किया था, primarily I was, मेरा view ये था और है भी कि these are not the litigations which can be entertained under 226, but now honorable coordinate benches are doing it. I am also doing it, but with the rider that where the court is convinced or the other party concedes that the amount is not disputed.
I will request. Sometime we going to seek instruction for this case as well. And we also received a letter from the executive engineer that we have pressure from the central government to settle the matter.
हाँ ठीक है, इसके पता क्या है, मैं आपको बताऊं pitfalls ये हैं that supposing a petitioner comes to the court who is hand in glove with some officer or official of the respondents कि सर मैंने 30 करोड़ का काम किया हुआ है और ये मेरे पैसे नहीं दे रहे, और इनकी तरफ से कोई डॉक्यूमेंट आ जाता है जिसमें है कि हाँ ये है, and a mandamus is issued by the court. What will be the?
But they are not giving audit what they have paid and what was to be paid.
What that is the job of civil courts.
Yes, and my lords, meanwhile matter can be settled out of.
यहाँ पे तो हाई कोर्ट की इंटेलिजेंस सिर्फ इस पर्पस से थी, आज की डेट में ये हालत है हिमाचल में कि ठेकेदार काम नहीं ले रहे हैं. I have been told that none of the contractors is willing to accept the contracts on the ground कि पिछले तो पैसे दे दो.
Yes, right, sir.
That is the problem. तो इसीलिए हम भी interfere. This court is also interfering now.
5 years I will maintain the work.
पैसे नहीं दे रहे हैं आज की डेट में मिस्टर एजी, and from the horse's mouth मेरे को जहाँ पे, और relating to the work of the courts itself. हमने बोला काम क्यों नहीं हो रहा, कहते ठेकेदार बोल रहा कि सर मैं करूं कहां से, जो किया हुआ है उसके तो पैसे सरकार दे नहीं रही.
The third case, more than 4 crore rupees is pending. In these cases of this.
नहीं जो भी है, but that is why I have also molded now myself and I am interfering.
No solution. K&K judgment is a very good solution. Very nice judgment, my lords.
As per the Article 226, 26.1 of the agreement. Arbitration.
These are the my lords.
No, question is arbitration. Question is you are choking. You are choking the development of the state. आज की डेट में मेरे को ये बता दो कि कौन सा ऐसा ठेकेदार है जिसकी आप पेमेंट्स जो हैं
keeping you the same situation in the state.
Who is the author of this judgment? I think Justice Sridharan, he has authored it. Sridharan.
Certain guidelines have been followed. Corrections have been given. Out of 26 lakh is also imposed.
इसमें लिखना, in the course of the hearing of this case, the learned counsel appearing for the petitioner has drawn the attention of the court to the judgment passed by the Honorable Division Bench of the High Court of Jammu and Kashmir in LPA number 121 of 2023, titled Union Territory of Jammu and Kashmir and Others versus Muhammad Afzal Reshmi, and has submitted that in order to address the issue of the grievances being raised by the government contractors of non-payment of their dues qua works executed on account of paucity of funds as an impediment. The Honorable Division Bench has adopted certain directions which were passed by the learned single judge, which stand referred to in the judgment. And as these guidelines are relevant even In this case, therefore, it would be in the interest of justice in case this court also issues similar directions, guidelines which are directions करते हैं. Next में करना. Taking into consideration the fact that this court is facing a number of litigations, stroke writ petitions being filed by government contractors who are seeking a mandamus from the court to the effect that the government agencies be directed to pay the due and admissible amount of the work already executed by them,
And completion and performance certificate you issue.
which amount is not being disbursed despite completion and
Performance
performance certificate being issued. This court is of the considered view that it would be in the interest of justice in case the directions passed by the Honorable Jammu and Kashmir High Court are issued to the state of Himachal Pradesh also with some modifications, so that the litigation can be avoided and the grievance of the government contractors can be redressed. Accordingly, the following directions are passed. The Chief Secretary of the state shall examine the issue being raised by government contractors of non-payment of the claims of executed works after getting input from all the departments and the agencies of the government which get their works executed through contract and are denying payment to the contractor, citing paucity of funds as an impediment. A chief secretary shall also ensure that such like matters are settled by the government at its own level, so that aggrieved contractors need the court. This obviously would avoid unnecessary litigation. Full stop. Second, Chief Secretary shall also examine constitution of a high-powered committee consisting of the principal secretaries of the concerned departments as well as principal secretary finance and such other officers as the chief secretary may deem fit to examine the claims of the contractors, and wherever such claims are found genuine, concerned department should make the payments without any further based on the recommendations of the said committee. Chief Secretary should also examine that in case there is any delay in the settlement of the admitted claims of the contractors, then the amount shall be paid along with interest at the lending rate of the interest of the bank. And here, the delay is attributable to officers stroke officials, then the amount of interest should be recovered from such erring officers or officials, of course by adhering to the principles of natural justice. ठीक है? Let learned additional advocate general, let the chief secretary to the state of Himachal Pradesh respond to the observations made by this court by the next date of hearing. List on dash 2 हफ्ते के बाद. Do this is a very good suggestion. This is a very good suggestion. ये सर हमारे को कॉपी दे दो. This is general. मैं वैसे general कह रहा हूँ. He is saying that probably the central government and state government are making an endeavor to have the matter settled. So why should we?
My lord, I think the sense of when the payment was to be within 30 days.
Only problem is that the work of the state is being hampered. That is what is worrying the court. Next. Yes, please. Mr. Bhushan. एक बज गया. Sir, 2 PM.